Good morning, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. Let's start our day in Miami-Dade and see what's going on with Judge Grumpy Pants.
14. He's out on bond. Hold. I'm not sure if there's, there should be a hold, I guess.
There's an added charge on it.
Okay, thank you. No hold.
Miss Heck, back on Mr. Cardona, do you have the first name of the alleged?
George.
George, thank you.
Good morning, Mr. French. You were arrested for tampering with an electronic monitoring device. It's from June 15th of 2025. I will appoint the public defender's office for you. So there is probable cause for the charge. Your bond is $2,500. Have a nice day, sir.
What did it say?
Tampering with an electronic monitoring device. Next, we have Jagamia McKenzie on page 14. It says added charges, 2 arrest affidavits. Good morning, sir. You were arrested for 2 cases from yesterday, battery by a detainee on another detainee. I will appoint the public
He
defender.
refused the public defender's office earlier, so we just need to know from him if he has a private attorney
Oh,
or
sir,
he needs to fill out the financial affidavit just like everybody else if he wants a public defender appointed.
Okay, sir. Would you like, have you hired a private lawyer?
I got a lawyer on my last case. Not private. She's not private though.
Would you like the court to appoint the public defender's office for you? If so, you have to fill out the financial affidavit to make sure you qualify. Would you like to do that, sir?
Oh man, I'll fill it out. Yes, ma'am.
Okay. All right. You want me to fill it out first, Miss Corey, and then we'll recall it?
Okay, we can run it.
No, Judge, I'll just tell my staff as soon as he leaves.
Okay. So, sir, you got charged with 2 new cases, battery by a detainee on another detainee. So I will appoint the public defender's office for you. There would be probable cause for the charges. That you need the first name of the
So
victim
it's
on.
the same victim in both cases. The first name is Gerardo.
So one was at 225, the other was at 657, which makes you
The
wonder
arrest one
what.
has different name on the second one. On 17258, there's no Gerardo.
Let me see.
It says victim Lopez Zacharias, and on the other one, it's the same victim, Lopez Zacharias.
First name is Gerardo.
Gerardo, okay. Bond on each case is $2,500. Please don't fight at the jail. You're just picking up more charges, sir. It's unnecessary. And stay in touch. You have a good lawyer. Listen to what she tells you, okay? Next case is going to be Edward Gibbs.
Judge, we can go back on Mr. Berry. He doesn't live with his aunt.
Oh, okay. Let's bring in Mr. Berry. Mr. Berry, I'm entering a stay-away order from the alleged victim whose initials are QM. No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, her home, school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay-away order, sir?
Yes, ma'am.
Okay, I'll set up bond 2,000 count 1, 500 count 2. Have a nice day.
Judge, he indicates he has an attorney, Theodore Matos.
On this case,
Mastos.
he'd be here if he had a lawyer. He hasn't hired him on this yet. He has to be retained.
I don't even know where that come from.
Okay. I'm appointing the PD, so he has a lawyer. All right, next we have Edward Gibbs on page 19.
Your Honor, Mr. Gibbs refused.
Thank you. There's Ms. Corey, would you like to accept the appointment? Want me to reset it?
Yes. No, Judge.
Appoint the public
waive it.
defender's office, waive presence. There's probable cause for battery by a detainee on another detainee. Bond is $2,500. Okay, now I'm ready to start on page 1.
Your Honor, we need out of turn number 54. That's on page 21. Tommy White.
Morning, Judge. I'm glad that you're a woman of your word. You brought me back in. You told me to do
What
a
is
couple days. I said you're a woman of your word. You told me to do a couple days
21?
in jail. You brought me back in.
What page though?
Page 54, page 21.
Page 21. Hi, Mr. White. Good morning. How you doing today? So, sir, it's an added charge that you were arrested for. I got it here. So it's from July 14th. The charge is petty theft, 2 or more convictions. I will appoint the public defender's office for you. So he grabbed a speaker, hygiene items, and walked out of the store and did not pay. So the total is $15, they're saying. And then he guess that's on July 14th. Sir, you are ordered to stay away from the Dollar Tree store at 32957 South Dixie Highway in Florida City, Florida. You're not allowed to go to that store and you must stay away from there. Do you understand, sir?
Ma'am, I understand.
All
Actually,
right.
does he have pretrial in his other cases?
Please, Your Honor, you told me you're a woman of your word.
I don't know what I did,
Right.
but if he's still
Correction.
here, he's homeless. How would he have free trial?
He indicates he has a place. Yes, he has no bond.
No bond. Oh, he's taken into custody on F-25 14607. Okay, I'll set a bond, $1,000. Don't stay out of that. And 1 second,
Can't go to pretrial.
$1,000 bond, stay out of that Dollar Tree. Next we have is Vivian Quinones, page 1. Good morning, ma'am. You were arrested for possession with intent to sell cocaine, possession with intent to sell LSD, possession with intent to sell psilocybin mushrooms, and possession of a weapon while committing an offense, and also possession of a place for purposes of trafficking in a controlled substance while armed. I will appoint the public defender's office for you.
So Judge, it's a search warrant. They found a bunch of different substances, the LSD, the mushrooms, the ketamine. But the amounts weren't so high. They also found almost $1,000 in a gun as well as baggies.
Looks like possession.
Armed possession. Okay. I don't know about possession of a place for purpose of trafficking in a controlled substance since she wasn't trafficking in anything.
Correct.
Count 1 is possession of cocaine. I don't know what the state wants to,
I mean, I think if she's got these baggies and a gun and the money.
she's sleeping on the
Something wrong with
couch.
giving her a little bit of a break. But would Your Honor set a bond given the circumstances?
I would ask if you would even consider pretrial, Judge.
Does she have money to post a bond?
No, Judge.
All right, so we're talking about 3 grams of cocaine.
15 grams of mushrooms, a little bit of LSD, 8 grams of ketamine.
Okay. 0.64 grams of LSD is not a little, it's actually quite a bit of you.
I mean,
That's
I
it.
don't know, it's the little stamps on paper usually.
Oh, all right. All pretrial services alternate bond, $2,500, count 1, $2,500, count 2, $2,500, count 3, count 4, ROR, count 5, no probable cause, release outright.
It's overstates objection.
Thank you. Order her in.
So it sounds like she had quite the pharmacy going there. Good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Tuesday. Good to have you here. Let's stay in Florida, but we'll head north. Wade Mercer doing his first appearances.
I have read the complaint. There is probable cause for this charge, ma'am. I've also looked at your criminal history, Ms. Sizemore, which appears to show, the best I can tell, according to the Department of Corrections website, you've been to prison 4 times. Is that part of your criminal history accurate, ma'am?
Yes, sir.
Okay, but the good news is you're not on probation as far as I can tell, correct?
Yes, sir.
And as far as I can tell, you don't have any pending charges. Is that accurate?
No, sir.
That's not accurate.
She got a pending ag assault maybe in 25-276 CF.
Is the charges are supposed to be dropped because nothing's been filed against me and no court date still.
Okay, let me take a look at it.
276.
I went up there Friday to the courthouse.
It's not on her criminal history for some reason. It is on the criminal history. It's just out of date. The packet that they've sent me starts in 23 and then it goes to 25 and then it goes back to, maybe the pages are out of order or something. So let me take a look at that case. Let's see if the information's been filed and what the status is. 25276 CF, possession of controlled substance, arrest, the first appearance on June 5th, surety bond on June 16th. I do not see an information filed. And we are more than 60 days since the date of arrest, but we have a new arrest. Mr. Mitchell, Mr. McDaniel, I'm assuming your request would be the same as a similarly postured case we had last week, sir?
Yeah, or
Mr. McDaniel.
maybe just, yes, Your Honor, it would be similar, or maybe just ask the state to give them maybe, I think the statute, the ordinance statute says 3 days, maybe to 63 days, which is over that now, but give them 3 days to see if they're gonna file an information, Your Honor. I mean, not
Mr.
sure.
Mitchell.
I'll speak to Mr. Gill
I have a
about
job,
it.
Mr. Mercer, I have a job that I work too.
But Your Honor, she is still subject to random UAs on the previous one right there. So, just want to bring that to your attention.
Let's see if there's a condition of random UAs on that first appearance.
It is, Your Honor.
Sure there
And there
is.
very well may be, but it's not on the first appearance sheet, which is a reoccurring problem. So the only way for me to know is to go watch the video. Ms. Sizemore, I don't mind watching the video, but my intent would be to ask the jail to give you your analysis and then take that into account. But I can only do that if there was a condition of random urinalysis when you were first appeared before. I first appeared you, so there's about a 90% chance that I did that. Do you remember if I put a condition of random urinalysis on your first appearance?
I don't remember.
Okay.
I think you
So
did,
Corporal-
but I'm not sure.
Corporal Drown, do you have notes there other than the first appearance sheet that might show whether or not that was done?
According to the sheet in her file, it was not written down, Your Honor.
I need some
Whether
glasses.
What sheet are you talking about, Corporal Drown? Are you talking about the first appearance sheet that's filed with
I'll
the
take
clerk? Or are you talking about some other form?
Listen,
the other form that's inside their file, we write down all their charges and what their bonds are and whatnot,
Okay.
but it doesn't say anything about random UAs.
She don't mind taking
I think-
money regardless, Your
I
Honor,
think-
so.
Okay, I still need to get this fixed with the jail because this has happened 3 times in the last 2 weeks.
It's
So
hard.
let me see if that's a condition the judge imposed. And Corporal Drown, if it is, I need you to go to the chief again and tell him whoever's making those notes is not writing it down. But before I even jump to that conclusion, let's watch the video. It should take about 30 seconds to do that.
I think it was on
And
there.
so now you remember it being on there, huh?
I think it was, I'm not sure.
Okay. All right, so let's see. June 5th was the first appearance date.
I had June 4th, at least on my sheet,
That was the arrest date or the first appearance date?
first appearance date.
Well, the date from the jail says June 5th. It says the arrest date of June 4th. So take a look, Mr. Mitchell, and see what you're looking at specifically.
It's the cover sheet.
I don't know what that is. We don't have a cover sheet. Who's that?
The cover sheet for the first appearance packet, June 4th is what I saw right there. Sheriff Sizemore. And I put 7.5K random UAs on there.
And that's from the jail?
Yes.
Yeah, I think that's wrong too. Because it looks like she's on the first appearance list for the 5th.
Yeah, she's on the 5th. Or
We got her.
it's the top of that page you're looking at,
John,
Jake, says
I
6'4", but it's.
I can't hear this while y'all are talking. The way the system works, it goes over each other. So give me a second to finish watching this. I can't. All right, so there is a condition of random urinalysis. Mr. McDaniel, you were saying something, sir?
I'll just let Jake know that the jail had put on the first appearance 6'4", but it was actually 6'5", and I probably should have changed that before I sent it to him. But yeah, it's 6'5".
Thank you. So Corporal, there are two issues. Once again, whoever's taking those notes from the jail isn't writing down what the judge orders when he says no random urinalysis. So we need to please try to correct that, make the chief aware of that. And the second thing is, what I'm going to do is I think Mr. McDaniel's request is reasonable. I'm not going to hold you 10 days because I don't see a point in doing that. If the state doesn't file information, you're sitting there for no reason. I'm going to direct that you be brought back. Today is Tuesday. Be brought back Friday. I'm going to ask the jail to give you a urinalysis after first appearance. If the state hasn't filed information by Friday, then the rules are very clear. I'm not going to revoke your bond. If the state has filed information by Friday, we'll cross that bridge and see where we land. But right now, no bond until Friday. And then we'll see where things stand as a result of that urinalysis that you're going to get today as a condition of your bond. Ms. Sizemore, do you have any questions, ma'am?
Yes, sir. Do you need to get my prescriptions from my doctor?
No, ma'am. What will happen is if you have anything like that, just tell Mr. McDaniel about it or tell the jail about it. But if you test positive, it depends on what's in your system. If there's methamphetamine in your system, I'm not aware of any legal substance that can cause. If you'll let me finish talking, please.
Sorry.
If there's methamphetamine in your system, I'm not aware of any legal prescription that can cause a positive UA for methamphetamine. If there's amphetamine in your system, that's different. If there's cocaine in your system, there's nothing legal I'm aware of that has a high probability of causing a positive urinalysis. So let's see what's there, and we'll go from there, okay?
Take Adipix, and it's going to pop up methamphetamine.
Yeah, and there are some substances that cause methamphetamine, so we'll look at that. Thank you, ma'am. We have Brandon Brown next. Mr. Brown, good morning. Mr. Brown, you're here for first appearance accused of 2 felony charges. They are scheme to defraud and theft, third or subsequent. Mr. Brown, the note from the jail says you're on probation, but I couldn't find that. I checked a couple of systems, different systems, statewide and circuit-wide. Is that a mistake, or are you really on probation somewhere?
No, I'm not on no probation. I haven't been in trouble in over 2 years.
Okay, I couldn't find anything, so that's good. That means you're entitled to a bond. Let me see if the attorneys have any additional information, Mr. Brown. There is probable cause for the charges. Let's see if they have any additional information they want to make me aware of before I set that bond. Mr. McDaniel?
Nothing, Your Honor.
Mr. Mitchell?
Just a second, Your Honor. I want to double check something right quick. No, Your Honor.
Mr. Brown, I'm going to set you the normal. Actually, was there restitution owed? I believe there was. Mr. McDaniel, the bond I had written down tentatively before hearing from y'all and hearing from Mr. Brown was $5,000 on each charge. That's the equivalent of $10,000. I don't mind a $1,000 cash bond because there's restitution owed if you and the state agree. Mr. McDaniel?
While he's talking, I have no objection to a cash bond.
Cash bond, Your Honor.
The bond is $500 cash in each count. Mr. Brown, that's $1,000 cash. Mr. Brown, your bond has a condition, no contact with any Walmart while the case is pending. Mr. Brown, let me ask you one more question. I think this is a mistake, but I want to make sure. This is not your mistake at all. 25,367. So part of the time I probably spent 15 minutes on this case this morning trying to figure this out, Mr. Brown. In the complaint, the investigator or the officer put the following language. Court disposition for 331 of 25 has court order no contact with any Walmart. The officer didn't say what case number, doesn't say what county or what state. I couldn't find any court disposition for 321 of 25 ordering you not to have any contact with Walmart. Are you aware of any? And I'm not asking about it. There's nothing pending. I think that's the wrong defendant. Personally, were you ordered in March of this year to stay away from Walmart by any judge?
No, sir.
If you haven't been in trouble in 2 years, you haven't been in front of a judge in March, were you?
No, sir. No, sir.
I couldn't find anything. So I think that's wrong, Mr. Mitchell. I think there's something. I think she's got the wrong. I can imagine Brandon Brown is probably a fairly common name.
Yeah, there's 3 of them from just my town.
She may have found a different Brandon Brown that may have been court ordered, but I couldn't find anything on this defendant keeping him away from Walmart. Mr. Mitchell?
That's what I was checking earlier because the name sounded familiar. I believe we had another Brandon Brown like at arraignments back in January or something like that.
Just to be clear, thank you. Just to be clear, there is a condition no contact with Walmart now because of today's bond, but there was, I don't think that was you earlier. Mr. Brown, any questions?
I mean, quite a few. I'll say I haven't been in trouble. Last time I was in trouble was with a Walmart, but I've been banned from Walmart for almost 5 years. I ain't stepped inside of a Walmart in at least 3.5.
Okay. I'm aware of that. Do you have any questions?
No, sir.
All right. Wish you the best, sir. Next case is Jason Beard. Mr. Beard, good morning. Mr. Beard, you're here for first appearance accused of 1 count of violation of state probation. I believe I saw you over the weekend in another county. Mr. Beard, there's no bond on this. What I want to do this morning is I want to get you arraigned because the sooner I arraign you, the sooner you get on the docket and the sooner we get you an attorney appointed. Mr. Beard, would you like to have an attorney appointed to represent you in this BOP?
Yes, sir.
I'm going to appoint the public defender's officer. I'll give you a chance to ask questions in just a moment. Let me get you attorney appointed. I'm going to appoint the public defender's officer of the 14th Circuit to represent you. Listen to Mr. McDaniel. We'll see if you have any questions in just a moment.
Your Honor, we're going to enter a plea of not guilty. Asked to set this on the next pretrial date, which is September 4th, and I advise him, Mr. Green, to come and talk with him about the issues that he wants to tell you about, and that he'll bring that to Judge Garcia's attention if he deems it necessary.
Thank you. Mr. Mitchell, anything?
No, Your Honor.
Mr. Beard, any questions?
I got, yes, sir, I got a question.
Okay.
My wife got proof that I've done all this stuff, all the community hours and the meetings and all that. She's got proof that the paperwork and the payments that I took care of all that. So what am I supposed to do about that?
Okay, I think I explained this. We went into this a weekend. I went over this kind of lengthy with you, explaining that each of the allegations against you. I told you were accused of about 6 different violations. Exactly 6. I read them to you, explained that to you. That's what you're accused of. If you've got defenses to that, that's what this process is for. Right now, the judge has ordered no bond, and one of the big ones is that you used methamphetamine and then admitted to it by signing a positive urinalysis drug statement. So that's part of the allegations against you. And you've got to see the judge on that. You're on probation, Mr. Brown. So, I mean, Mr. Beard, you're on probation when it happened. So you've got to deal with that. And I understand you may have defenses to some or all of them. That's what the process is for. You need to talk to your attorney about that. You can get your wife to go ahead and contact Mr. Green and get him that information. Mr. Guy Green is your attorney in the VOP case, or will be your attorney. And then when he comes and sees you, he'll already have that information. So you may want to call your wife and let her know that. You do have the right to use the phone to call her after first appearance and let her know what's going on with the bond, okay?
Yes, sir.
Have a good day, sir. Tommy Blizzard. Mr. Blizzard, good morning. Mr. Blizzard, you're here for first appearance accused of 1 count of possession of methamphetamine and 1 count of driving with no valid driver's license. Mr. Blizzard, I've read the complaint. There is probable cause in the complaint. Mr. Blizzard, your criminal history is not bad at all. If what I have is correct, I show a prior no valid driver's license in 2016, and that's it, nothing else. Have you ever had any other charges besides that?
No, sir.
Perfect. Let's see if Mr. McDaniel or Mr. Mitchell have anything else I need to be aware of. Mr. McDaniel?
Nothing, Your Honor, except there is a child support writ out there for him. I think it has like a $2,800 purge. So that's the only thing, just let you aware of that.
Corporal, has that been served? Thank you, Mr. McDaniel. Corporal, has that been served or is it not served for some reason?
Not served, Your Honor. We just heard about it this morning. I still got to call SO and have him come serve it.
Okay. So Mr. Blizzard, Mr. McDaniel's extremely thorough. I'm confident that he's accurate. And what that probably means is the deputy that brought you in, they're supposed to do a records check. Sometimes they miss things or dispatch misses things. I have no idea. But what I'm going to do is, well, you're going to be a conditional release candidate, but I can't give you a conditional release.
Can I say, I've already been to jail on this.
I can't give you a conditional release if you can't get out. So give us a second to pull that up. Given your history, I was going to consider a conditional release for you, but, and I still may. Just got to figure this child support thing out. Did you say that you've already been to jail on the child support?
Yes, sir. They came out and picked me up and took me, and somebody met my purge.
When was this? Give me a time frame.
I really don't know the exact time, but they came and to my house, and they came and picked me up and took me to jail. I was in jail one night, and then Nikki, my baby mama, she either withheld it or something happened, and I got out.
Was that this year?
This year.
Jackson County?
Yes, sir.
So, Mr. McDaniel, did you know the case number? I want to make sure I'm looking at the right case. There is a writ in 15-722 CA.
It may have been served in, Your Honor. They may have it in the administrative case because the jail has a note that there was an order entered to release him. So I apologize. And I think they have it in the administrative case.
Yeah, I've been to jail already.
And I think you know that I think you're right that the clerk system shows a writ. This first thing it flashes, it comes up, but then it says there's also a final order terminating support, determining arrears and establishing payment on arrears. That was in 23, and there's no writ after that. So I'm wondering if there's an old writ that's been served, but it's just not out of the clerk system for some reason.
I showed that it hadn't been served, and that was the reason why they had modified that order to an arrears only order, but the writ had never, I showed that it had never been served, and he's never made a payment in the case. I did look at the pay history, and he's never made a payment, so I know the purge wasn't paid.
So if there's I know that you know a lot more about child support than I do, Mr. McDaniel. If there's a recorded order, well, let me just go to the actual order and see what it's called. Sometimes the clerk's office doesn't match exactly what the heading of the order is. Most of the time they do, but there's a final order terminating support, determining arrears, and establishing payment on arrears. Does that type of order affect a pre-existing writ?
The writ was already out there. It would not affect it. It just means that the amount that he's paying would change. They terminated it. And I don't know if it was because the child's were gone or if they emancipated. I'm not sure.
So what I'm going to do is this. Thank you, Mr. Daniel. Mr. Blizzard, Mr. Blizzard, listen what I'm going to do. I'm going to set your bond today. I'm going to set your bond at $2,500 on the felony charge and $1,000 on the driver's license charge. It's $3,500 cash or surety. You've got a condition of random urinalysis, and you've got a condition not to drive without a motor vehicle. I'm going to ask the jail to check on the child support matter because you need to know if there's a writ or not. If there's no writ, then I'm going to see you tomorrow if you're still there. If there's no writ, it's been satisfied, you're a conditional release candidate. In the meantime, you don't have to wait till tomorrow. You have the right to post the bond today if you wish and if you can, but there's no point in posting the bond until you get the child support matter issue answered. So let the jail tell you if there's a child support. Once they tell you, you'll have some guidance on what you need to do. If you want to accept the conditional release, you can do that tomorrow. If you want to go ahead and post bond, you can do that today. but you will not be released until the jail finds out if there's a child support writ, and if it's active, it appears that there may be. Frankly, I can't tell. Any questions, sir?
No, that's it. I'll see you tomorrow.
Yes, sir. We'll see you tomorrow. Mr. Mitchell, I don't think I asked you with any other conditions other than normal random
Your Honor.
analysis request.
No, Your Honor.
William Jackson.
Judge, I just looked at the order. They got it in 19101. So I guess there's, it's, the writ's been taken care of. So if you want to give them a conditional release.
Well, the clerk's file is still showing a writ in 15722.
And I'll be honest with you, that will be the administrative case. And I think that I'll talk with the clerk's office.
Yes, I'd like you to look at that, Mr. McDaniel, and then I don't have a problem giving the conditional release. I just can't do it if there's an active writ. So, Mr. McDaniel, once you look at that, if you determine it's an error, please let us know that. Otherwise, we'll see him tomorrow.
Okay.
William Jackson.
I have no objection to any of it.
Mr. Jackson, good morning. Mr. Jackson, you're here for first appearance accused of one count of, good morning. You're accused of one count of DUI and one count of leaving the scene of an accident with damage to property. There is probable cause for the DUI. I'm not convinced there's probable cause for the second charge. I texted the attorneys this morning, made them aware of my concerns. So I'm going to hear from the state first on the leaving the scene charge. Mr. Mitchell.
Your Honor, you can just go ahead and grant him an ROR, find no PC in that. More than likely, if this case were to be resolved, I would dismiss that charge anyway and go on the DUI by itself, which is a stronger case. So we'll leave it up to the court's discretion.
Thank you, Mr. McDaniel. Do you agree?
I agree. I agree that, it has sufficient evidence. I'm assuming that they're alleging basically DUI is based on that he was at his house and he had the keys in his hand. And that's what they kind of said that the officer seen him there. So I agree there's proper cause for it, DUI. I don't think they went into any kind of details on how he, someone witnessed him in the accident and stuff. But I think they were basing, what I could tell, it looked like they were trying to base it on the other officer seen him at his house with the car. Was that your assessment?
Yes, exactly. So Mr. Jackson, the extent of the allegations, the only thing they reference about leaving the scene is trooper, I'm not gonna say the trooper's name, I don't know how relevant that is. One trooper advised me that he collided with a semi on the interstate and left the scene of the crash. Well, how did that trooper get the information? Did the trooper see it? Did somebody tell it? I don't know how, I have no idea. The bottom line is they got to tell you how the other trooper got the information, because it doesn't matter what the other trooper tells you. What matters is where did they get the information from? There's no probable cause for leaving the scene at all. They don't even say, did the truck driver say it happened? Did you say it happened? Did a witness say it happened? I have no idea. There's no probable cause for that. There is probable cause for the DUI. And based upon your history, I'm going to set your bond at $2,500 on the DUI. So you don't have to post a bond at all on the second charge. On the DUI case, you've got a $2,500 bond with a condition, no alcohol. At this point, no alcohol at all, can't possess or consume it. Mr. Jackson, you get a chance to use the phone in just a few minutes, sir, to try to post that bond. Do you have any questions?
Yes, sir. I have to go to work today. I have a job.
You can do that as soon as you post bond. You get out there and go to work. I'm not going to let you out without a bond because of your criminal history.
I don't have that type of money. I don't have those kind of funds.
If you don't post bond, then you're not going to be released from jail. If you do post bond, you will. So I'm not going to give you a conditional release because your history is not good, Mr. Jackson. Do you have any questions?
I got a job,
I understand that. I saw in here where you had a job. I even looked at that. It said that you worked at Wendy's and you've been there 1 year.
Yes, sir.
But you've got it. Your criminal history is probably, I don't know, 10 or 12, 15 pages long, maybe.
I ain't been in trouble. I ain't been in no trouble. All
you want to finish that sentence? You haven't been in trouble. Haven't been in trouble how long? Well, you've been in a lot of trouble.
Since I've been released.
When was that though?
2020.
Okay.
So I ain't been in trouble in 5 years.
You probably have. I'm gonna look here. I would say
I don't do nothing but go to work and come home. That's all I do.
15 arrests. Yeah, I'm not getting you a conditional release with that criminal history that you have. I wish you the best, sir.
All right, thank you.
Yes, sir. Roberto Torres. Mr. Torres, good morning. Mr. Torres, you're here for first appearance. Accused of one count of driving with no valid driver's license and one count of possession of methamphetamine. Mr. Torres, there is probable cause for those charges. You have a very long history, it appears, and it appears you're on probation out of Calhoun County. You're still on probation, right, Mr. Torres?
Yes, sir. I haven't been in trouble. I don't know how they took me.
Nothing you're gonna say.
Huh?
Nothing you're gonna say. Mr. Torres.
I
Mr. Torres,
didn't have it.
I'll give you a chance to ask any questions in just a second, okay?
Okay,
But what I'm gonna
sorry.
tell you is that since you're on probation, Mr. Mitchell is on probation in two different case numbers, 23-161 CF and 23-162 CF. There's a 10-day hold for those two cases. No bond for 10 days, Mr. Torres. I'm asking Mr. Mitchell to notify the probation office of your arrest, and we're gonna see if they file a violation or not with the Calhoun County judge. I'm gonna set you a bond in Jackson County because you're entitled to one, but don't try to post it because you're not gonna get out even if you do because of the Calhoun County 10-day hold. It's $5,000 bond on the misdemeanor criminal traffic and $10,000 bond on the methamphetamine. Random urinalysis condition on the methamphetamine and no driving condition on the no valid driver's license. So Mr. Torres, you've got a $15,000 bond, but don't try to post it because when you're on probation and you get a new charge, there's the possibility, perhaps even the likelihood that they will file a violation against you and seek a warrant for your arrest. And if they do, the Calhoun County judge will be the one to decide whether or not to sign the warrant and whether or not to issue a bond. Now, I'll try to answer any questions if you have any, but you don't want to talk about the charges against you because we are being recorded. You have a question, sir?
No, I need to talk to him. Good luck to you.
All right. Have a good day, sir. After Mr. Torres, we have Courtney Mead. Ms. Mead, good morning. Ms. Mead, you're here for first appearance accused of one count of dealing in stolen property. Ms. Mead, there is probable cause in the complaint against you, ma'am. Ms. Mead, your criminal, the good news is your criminal history looks really good. I don't see much, if any, prior criminal history. Is that accurate, ma'am?
Yes, sir. I've never been in trouble.
The bad news is this is a second-degree felony, and it appears to be a particularly egregious second-degree felony, and there's significant evidence against you in this case, Ms. Mead. So those are the factors I've got written down. Let me see if the attorneys have any additional information. Mr. McDaniel, I'm considering a cash bond, but anything you have that I might need to know about, I'm glad to listen. Just ask, that's fine. You're on a cash bond. Mr. Mitchell.
No objection to cash bond.
Ms. Mead, I'm gonna set you a $500 cash only bond, ma'am, as opposed to a surety bond, and I'm taking into account, that's probably a little lower than normal, but that's because your criminal history is so good. You have a condition, no contact with the alleged victim at all. You'll get your phone in a few minutes, ma'am. You post that $500 cash bond, you'll be released. Ms. Mead, do you have any questions?
No, sir.
All right, ma'am, have a good day. Brandon Hill. Mr. Hill, good morning. Mr. Hill, I show a hold out of Bay County. You were being brought back on. I checked the Bay County file this morning. And so, Corporal, what the jail sent up is an affidavit filed in that case, not a warrant. But I went and checked to see if there was a warrant, and there is. So, Corporal, do y'all have the warrant? I just want to make sure y'all have it out there. Do you have the warrant or just the affidavit?
Looks like we got the affidavit only, Your Honor.
Okay, so there is a warrant in that case. Mr. Hill, you're accused of violating your probation, and the warrant has no bond on it, I believe. I think I saw, I think it was Judge Register's signature, but Mr. Hill, you got no bond from Bay County. What I cannot tell from the jail sheet is whether he has local charges also or not. Mr. McDaniel?
No, he don't.
Okay, so if this is all you've got, Mr. Hill, you'll go to Bay County. They've been notified, if they haven't already, to come pick you up. You'll deal with these accusations against you down there. Mr. Hill, do you have any questions?
Who?
All right, have a good day, sir.
Okay.
He say who or no? No. All right. Next, we have Keith Knox. Mr. Knox, good morning. You're here for first appearance. Again, I saw you this weekend for 3 charges: DUI, no valid driver's license, no registration. Mr. Knox, I took a real close look at your case today because you were kind of on the line for a possible probation offer. You got a long criminal history, but it looks to me like you haven't been in trouble since 2015 or so. Never had a DUI before. So based upon that, there's a tentative offer made. I think the state's in agreement with this. Let's see what Mr. McDaniel in your position is. Please listen to your attorney. I'm appointing them for first appearance purposes. And Mr. McDaniel.
Your Honor, I spoke to Mr. Knox in 25-430 CT. He's going to plead of no contest to the charges as listed. The understanding he'll be placed on probation for 11 months, 29 days on the first degree, 6 months on the 2 second degrees, all run concurrent. $1,078 in fines, 50 hours of community service, minimum driver's license suspension, AA classes as recommended by probation, DUI school. And he has signed his waiver, waiving his right to a jury trial, and called witness to be adjudicated guilty. And this will resolve this case this morning.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor. I guess just for, what was that?
We have
Oh,
Mr.
no.
Burry on.
I think they
Is the
accidentally
jail,
logged in.
are they still doing first appearance? Yeah, let's.
Yeah,
Yeah, we're on the last
We're on our
one.
last case.
Can I ask you one question?
But would it be easier, instead of putting on 2 concurrent probation sentences, to dismiss the no valid DL and no motor vehicle registration?
That's entirely your call.
I mean, I'm fine with that.
Okay.
It makes it a little bit easier.
Mr. McDaniel, you okay with that?
What was that, Your Honor?
Mr. Mitchell, rather than being on concurrent probation, he wants to take the longest case, which is the most serious case, the DUI, dismiss the other 2.
That's fine, Your Honor. Also, no driving a motor vehicle without a valid driver's license.
Okay. Mr. Knox, did you hear that agreement, sir?
Yes, sir. What is it?
Everything I said.
Yes, sir.
So, Mr. Knox, I know you've got quite a history, but Mr. Knox, you've stayed out of trouble for about 10 years. So I think you're a candidate for probation. If you want to do it, it's not easy, but you certainly have shown that you could do that and could complete it if this is what you want to do. Is this what you're going
Yes,
to do
sir.
with probation?
Yes, sir.
Mr. Knox, I'm going to accept your plea of no contest to the charge of driving under the influence. State's dismissing the other 2 charges. Mr. Knox, I'm going to adjudicate you guilty of that offense, find that your plea is freely and voluntarily entered with the advice of counsel. I'm going to sentence you to 11 months and 29 days probation. Mr. Knox, you will have the standard conditions of probation. In addition to those standard conditions, you will have the following special conditions. Court costs and fines will be imposed. That'll be the amount of $1,088.
78.
$1,078. Mr. Knox, successfully complete substance abuse counseling, 50 hours of public service work, DUI school. I do recommend the minimum driver's license suspension. You'll have a condition not to operate a motor vehicle unless you have a current valid driver's license. And if you choose AA, we'll put a cap on that of 12 classes. So, Mr. Knox, in the criminal case, they're going to let you get dressed and let you use the phone. The reason for using the phone is in case you want to call friends or family to pick you up. If you do call someone to pick you up, you can tell them that you can be picked up at the courthouse in 30 to 45 minutes. Once you get here, the probation officer will go over the terms of probation with you. They'll give you a copy of the rules in writing. They'll give you a chance to ask any questions, and then you'll be free to leave 30 to 45 minutes from now. Mr. Knox, that resolves the criminal case. In addition to the criminal case, you had a citation for no proof of insurance. If you want to plead no contest to that, I'm going to waive the points and waive the fine on that. The reason I would do that is because you've already got a big fine in the DUI. Do you wish to plead no contest and no proof of insurance if I waive that fine?
Yes.
Show a plea of no contest, please, to no proof of insurance, withhold the points, waive the fine. Mr. Knox, we'll see you at the probation office in 30 to 45 minutes. Any questions?
No questions, John.
Have a good day, sir.
All right, he'll be wrapping up there now. Let's go to Texas. We'll say good morning to Judge West.
So I'm glad to be here.
We're glad you're here.
But, you know, as I've said before, getting old is not for young people.
Good morning. Are you Ronald Spites?
Yes,
and Mr. Spites is charged with the offense of manslaughter in cause number 25 DCCR 0920. Mr. Macon has filed a motion asking me.
No, he was arrested for murder and indicted for manslaughter.
Intentionally and knowingly causing the death of an individual. Let me look at the indictment. It shows I don't know why the heading
says manslaughter, but the language.
did then and there intentionally and knowingly cause the death of an individual, namely Rowan Williams, by striking him with an automobile. So at least on the indictment, language, that would be murder. I know it's not, the headings are not sometimes important, but I think that needs to be adjusted and changed, especially if that is what is in, that's what's in Odyssey. So that's showing up on everything with the wrong stuff. So that needs to be amended if you can. Take care of that later. So based on that, it looks like the offense is actually the first-degree felony offense of murder, Mr. Spites. And Mr. Macon has filed a motion asking that I reduce your bond. Did I print? No, I'm printing it now, the PC. Bond is currently set. Sorry, I've got too many things I'm thinking about trying to do right now.
It's $800,000.
Thank you. Currently set at $800,000. Mr. Macon, do you wish to call your client?
Yes, Your Honor.
Sir, if you'll please raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Macon.
Now, what's your name?
Ron James Spikes.
And Mr. Spikes, you're the person charged with the offense. Okay?
Yes, sir.
Do you have enough money, either you or your family, to post a $800,000 bond?
No, sir, I don't.
Okay. Now, before you were arrested, I mean, in the past, you were in lots of trouble, right?
Yes, sir.
And you've got some priors, but in the last 10 years, have you been in any trouble?
No, sir, I have not been in no trouble.
Okay. And you have your wife living in this area?
Yes, I have my wife, my family, and things.
Okay, and your family, and you have a job, were you able to make bond?
Yes, sir.
And that's with your father-in-law, Mr. Gonzalez, correct?
Yes, sir. Yes, sir.
And that's at 365 Scrap?
No, yes, sir.
Okay, and did you also work for Zachary as a heavy equipment?
Yes, sir, I do.
So you've always been working, you know?
Yes, I have.
Do you have any assets whatsoever? Real property, coin collections,
No,
anything
sir.
like that? And you're asking the court to set some reasonable bond so you could get out and go home?
Yes, sir.
Mr. Smith, any questions? All right, any other witnesses?
No.
Mr. Smith, what is the state's position?
Judge, he does have a prior from 1998, where he sentenced 4 years GEC. So whatever if it's murder, he would be 15 to life at least. And if it's manslaughter, it's 5 to life. State court is reasonable for us.
Mr. Macon?
Your Honor, we think that $800,000 bond is excessive and would ask that it be lowered.
I am taking judicial notice of the court's file, which includes the probable cause affidavit, as well as there was a letter of support that was sent by Mr. Macon from a Rocky Johnson. Were you able to review that, Mr. Smith? I think it was emailed.
I believe it is.
Okay. Let me take a look at this real quick. And the prior was from when? 90?
98. November 16th.
Okay. Speak up, please.
It was from November 16th of 1998 for a 4-year sentence.
All right, 2 possession of controlled substance, same date. Got it. Okay. What I'm going to do is I am going to grant the motion for a bond reduction. I'm going to reduce the bond to $500,000. Sir? Did you want to say that again louder? You did say something.
Well, I didn't say nothing to him.
I'm going to reduce the bond to $500,000. A condition of that bond would be, if you make it, that you are on house arrest and required to wear a GPS monitoring device at all times. And we will get the case set for an announcement as quickly as possible. Right, sir? That's what it's set at right now, all right? You can go back with the bailiff. What?
I'll be back.
While she lines up her next contestant, let's stay in the building, but we'll go over to Judge Stevens.
Mr. Jones, it's an announcement. Yeah. Announce something.
We would ask for a reset. To
No.
allow them to-
Well, not for another announcement. I mean, where are we headed?
Mr. Kelly and I need to talk about this case, and we haven't had a chance to do that yet. This is not a very old case,
Yeah.
so
October will be a year. Yeah, so it's 10 months. But y'all need to talk, and 10 months have gone by. The baby can be born in that liquid time. So how, 4 weeks good?
I think 4 weeks would be fine for him.
Is that gonna be good? Okay. All right, okay. Get a reset it. Thank you.
Thank you.
Next one, please.
Okay, is Stephen Dodd here? Come on up, please. Your attorney is Mr. Reisinger?
Yes, sir.
Where's his office? Is it in Beaumont?
Woodville, Texas.
Woodville.
Yes, sir.
Okay. This says he's unable to be here. Do you know why? Did we know why?
I think he called Elliot like 4 o'clock. He had a hearing in another county. He didn't be here, so.
Something was more important than us? Well, I mean, you're looking at up to 2 years in a state jail. This is pretty important.
Yes, sir.
And it's over heading toward a year and a half old from filing. That's, we're sensitive about cases languishing here. We don't like to do that. I'm going to reset this just for 2 weeks, but Mr. Reisinger needs to get here. I mean, this is important too, but we set this last month on the 8th, July 8th. So I'm going to reset this 2 weeks. So you're coming from Woodville too, aren't you?
Yes, sir.
Payne.
Here's my responsibility.
And you're doing good. Thank you. There's not a problem with you at all. Then attorneys get busy in different courts, but you're just as important as any other, no less, anybody. Then we'll just have to reset it 2 weeks and hopefully, who's the lawyer on this one? Have y'all, I mean, this is over a year old. Where's this?
Conversations
That's
about it.
good. What is that? And the result of that,
I can't speak for the defense attorney. I don't know. I know that we've had conversations about the case, but.
yeah, I would think by a year, decision one way or the other needs to be made. And this is over that, so I'm just going to reset it 2 weeks. Hopefully try to figure out what direction your life goes.
Yes, sir.
Yes, sir. But I don't see any prior convictions on this. So Sarah,
Sure.
this is criminal history. Does he have any at all?
Yes, sir.
Yes, he does, Your Honor.
I've been in trouble for 20 years. Sir.
Good. That's good. But there's nothing enhancing though. I don't see an enhancement on there. Does he have anything that would enhance the punishment?
He does, Your Honor.
Give me a,
Why we did file an enhancement, I think we got.
what's a state jail felony?
Yes, Your Honor.
That it would it enhance the state jail? Is it just one conviction?
He has 2 prior convictions.
Two can hurt on a state jail. One won't enhance a state.
But I believe that one of them was a straight probation, so it's not enhanceable. Because it was not a,
Okay. So
so it's just a state jail.
yeah. Could have been worse. Fix it.
Yes, sir.
Responsibly and move on with your life. Yeah.
Yes, sir.
Get a resetting 2 weeks. Yes, sir. Lisa Kala?
It's not there on that.
Oh, yeah.
Yeah.
25 CR 448. John West is here with you. Yes. Initial.
It's initial.
Yeah. The beginnings.
Yes.
As you know, ma'am, you were charged here with a fraudulent use or possession of identifying information or items, more than 5 but less than 10 pieces of identifying information. Looks like credit card numbers, debit card numbers, driver's license, et cetera, without the consent of the named parties on those is what this alleges. If convicted, this is a 3rd-degree felony, which carries with it up to 10 years in prison. So you got to deal with it responsibly, seriously. Mr. West, anything today we need to discuss?
No, Your Honor, it's just our initial first meeting. I'm going to talk outside and get some set and get the discovery and do.
Okay.
Normal procedure.
Yeah, I was just going to set an announcement here for 4 weeks.
That's what I was about to ask him.
Okay. Unless y'all decide otherwise. Okay. Thank you. Yeah, he's going to talk to you. Just get a resetting. Thank you. Go roll it.
Yeah, by the X.
2 cases, Mr. Figueroa.
Yes, Your Honor.
Looks like this happened on the same time. Looks like 2 officers must have been assaulted, because he started with assault on a peace officer. And these are 2nd-degree felonies in these cases, which carry with it up to 20 years in prison in each case. Serious. Yes. John. He lives on Lay Avenue. I did.
Oh, okay.
I was on the 32. I grew up on 3200 now. It's a part of that's about a block away. But anyway, that's not important. Trivia. Today, what do you want to do?
Your Honor, if we get a time to go discovery and do all the things we need to do, this is an initial also.
Okay, 4 weeks.
Yes.
David Rogers.
Front row. Now, this is actually an announcement. This is not an initial.
Yeah.
We've been working on this, trying to get this resolved. At this point, I think we should just set it for.
That's a year.
Yeah, exactly. Because it's a year old. Set it on the trial docket. And if I do get something solved, I will, but let's go and get on the trial docket that way we can.
Who? Okay. The complainant in this case, the victim, who is that? I know who it is, but how is the relationship?
It's a spouse.
What's going on that? Do y'all have any contact with each other?
No, sir.
You can't.
Yeah.
If you did, your bond would be revoked. If I find out, your bond would be revoked and you'd sit out in jail until this thing ever got resolved.
We had this issue at the very beginning.
Yeah, like 2,500 cases.
That's why I'm refreshing your memory. And he had this conversation with him, and then since then he has ceased all communication and contact with her because at first it wasn't somewhat of an issue. So yeah, he's well aware of that. We've talked about it many times. He's gonna,
Yeah, it's only, nothing good ever comes out of not following the rules, and there was a reason for that. We certainly want to freeze the situation where it is and not getting any worse, and work from there to try to resolve it. Is there, are y'all still married? I guess? Yes.
technically still married, yes.
Okay, are divorce proceedings occurring or anything like that? No. Okay. How long have you been married?
4 years. Going on 5.
You almost hesitated trying to figure it out. Guys get in trouble for
That's just
having to think about it.
That's a guy problem.
Well, he's thinking about some other things right now.
Yeah, it is.
Not doing math.
Yeah. Right now.
All right, is 4 weeks going to be good for us here to figure out
Yeah.
what direction this goes in?
You know, I'm trying to.
He's never been in trouble before.
I don't believe so.
No, right?
No, sir.
Yeah, well, this is a fixable thing.
Yeah, it is, and I think we might be able to get it resolved. But I actually don't want you lingering on the nails, talking over and over and over again. Let's put some urgency on this. We can get it resolved
Okay.
because of the age of the case.
All right, 4 weeks, okay? Get a reset.
Get resetting. Yeah, we're gonna talk. Absolutely. Yes, please.
Sign on the next one.
All right, let's switch it up. We'll go next door, go back to Judge West.
I think Mr. Sorry.
Philip said that the discovery exhibit for one of those is being sent by Sarah since I didn't have it.
Oh, okay, thank you. Thank you, Mr. Smith.
Sorry.
All right, are you LaCaven Jenkins?
Yes, ma'am.
And Ms. Perazzo, will your client waive the formal reading of the indictment in each case? Mr. Jenkins, in cause number 24, DCCR 1026, you're charged with the first-degree felony offense of aggravated robbery, and that is from March 3rd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then, in cause number 24, DCCR 1027, you're charged with the third-degree felony offense of fraudulent use or possession of identifying information from March 12th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? Answer out loud for me, thank you. And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents in each of those cases that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazzo?
Yes, ma'am.
And do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Jenkins is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 24, DCCR 1026, find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Let's see, is there a, I am making an affirmative finding of a deadly weapon in that case. And then in cause number 24, DCCR 1027, also find sufficient evidence to find you guilty, and at this time find you guilty of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Perazzo. All right, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Perazzo. Mr. Wilkerson, you've got Larry Fletcher. Looks like that's also a bond hearing.
Absolutely, Your Honor. And Larry Fletcher, Your Honor, we have a number of witnesses here.
All right, give me just a minute then.
Yes, Your Honor.
All three of yours are bond hearings?
Yes.
Okay, give me just a minute then. Huh?
All right, while she sorts where to go next, let's head just a little bit east to the great state of Louisiana and see what's up with the Board of Pardons and Parole this morning.
Manager. Okay, and we have before us Ms. Flowers. Good morning. Would you introduce yourself? Tell us your name and your DOC number.
Audrey Flowers, 183680.
All right, and let me acknowledge you have some guests there with you at LCIW. You have your sister Dolores Landry, nephew Prone, and your daughter Central Flowers.
Yes.
Also in support on Zoom, we have the Parole Project. Mr. Hunley, would you introduce yourself for the record?
Andrew Hunley, Louisiana Parole Project.
Yes, thank you, and we'll hear from you shortly. We also have some folks in opposition, Ms. Flowers, here with us in Baton Rouge. We have representing the victim is Janae Brown, Edward Wilson, Dawn Urson, Janice Madison, and Melissa Pugh. And on Zoom, we also have Mabel Landry, and we'll hear from Ms. Urson and Ms. Landry at the appropriate time. First, let me just read some identifying information into the record, Ms. Flowers. You're classified as a third felony offender. You're currently serving a 40-year sentence. You were sentenced initially in December 2002 for simple arson. You received probation that was revoked in 2006 because of a new felony conviction, which was also in Iberville Parish, of manslaughter, for which you received a 40-year sentence. So this is a rehearing for you. Your parole eligibility date has passed. It was July 14th, 2023, and your adjusted mandatory release date, good time date, is October 16, 2042. Does all that sound correct to you?
Yes, ma'am.
So your case has been assigned to Mrs. Ledoux this morning. So before I turn it over to her, we want to hear from you and your guest, and then she'll start the interview process with you. So Ms. Flowers, tell us a little bit about how you ended up in jail, what got you there, and why do you think we ought to grant you an early release?
Well, what got me here, that I took somebody's life. And I'm sorry that it's happened. I didn't aim to though.
Okay.
And I asked you just give me another chance, and I could prove myself if I make parole.
Okay, well, we'll dig a little deeper into that in just a few minutes. Let's hear Warden Thomas. What can you tell us about Ms. Flowers?
Yes, ma'am. Ms. Flowers arrived around 2006. She has not had any disciplinary write-ups in about 10 years now. She has completed various classes. Right now, she is living in our medical infirmary, like assisted living area. So not major medical, but so she's not currently working, is what I guess I'm trying to say. I guess you all have seen the letter from education. So she has not completed her high set, but she did try very hard with literacy classes. But Ms. Schumate did not think that her high step would be able to be obtained at this point. And I know Mr. Hunley will probably go over a lot of the parole project if she is granted, so I'll leave that for him.
Okay, thank you. So, yeah, Mr. Hunley, could we hear from you in the parole project, please?
Andrew Hunley, representing Louisiana Parole Project, to affirm to the board today that Audrey is a client of our organization, and we stand by ready to present reentry support to her if she is given an opportunity for release. We decided to take on Audrey as a client based on her age, the amount of time that she's served on this sentence, and her institutional conduct record. Her reentry plan would be a bit different from what we normally propose to the board. Because of her age and her health, our organization would prefer that she complete an ICOTS to live with family out of state, who will be able to take care of her long term. What we would recommend is she starts that ICOTS. When the ICOTS, whether the board decides once the ICOTS is started or completed, we would ask that she come into our program for approximately 60 days, where we can assist her with some initial reentry support, work with the family on developing a long-term plan in the area where she'll be residing, help her with her initial issues such as health insurance, getting her primary care appointment, getting her medications and scripts rewritten, and then eventually transitioning her to that approved ICOTS resident out of state. You know, we're concerned in our ability to house her long term because of, you know, deteriorating health and her age, but we want to be able to assist her and her family with her initial release into the community if she's given that opportunity. Obviously, she would have the support of our social work team to help her during when she's initially released, and building a plan that carries over to her long-term address. And we would help her with initial programming, you know, in those first couple of months home, to ensure that she's got a crash course on technology and social norms. But I stand ready to answer any other questions you may have about her reentry plan. We believe that if she's released, the best long-term plan is with family out of state. And I'll reserve my comments at this point. Thank you.
Thank you. So let's hear from family. Could we hear from Ms. Dolores Landry, please?
You can stand up.
Closer to so I can see.
There you go. And you can speak.
Okay. I want to apologize to the Wilson family for what happened. And Audrey was the type, worked every day, didn't have money, didn't have underclothes, didn't have food. Because Mr. Wilson took every penny from her. Her retirement. She lived with him forever. He decided to take his wife back. Brought her back home to my mother with 6 pieces of clothes. And my mom said, this all she got? And she worked every day? It's just, like I said, all I could say, I'm sorry to the Wilson family.
Yes, ma'am. So if Miss Flowers was successful, would she go live with you?
She could. My mama living, her daughters, she got 2 daughters in Texas.
Okay, so the out-of-state plan would be Texas.
Yeah.
All right. Well, thank you, Miss Landry. We appreciate hearing from you. What about the nephew, Mr. Willie DeCrone? Is there anything you want us to know?
Yeah. Yeah.
Okay.
Go ahead.
Good morning. How you guys doing?
What would you like us to know?
All right. I want you guys to know that I am the nephew of Audrey. My grandmother raised me, and when she started living with us, but before she started living with us, we'll all go to her house. She used to work at the schools, and we'll go to the feeding program and get to see her, and she would feed us and talk to us and, give us good words of encouragement. But I also want to let you guys know that I do want to apologize to the Wilson family as well. It was a tragedy that happened that hurted all of us because we all was family. We did go to the Wilson house. They did come to our house, so we all knew each other. So it hurted us on both sides that happened to the Wilson, and it hurted us that we lost our loved one by going to prison. I also lost my brother maybe 4 years ago. He was killed by a lady, shot in the back. I went to that trial. I sat in that trial. I listened to it, and they gave her 20 years. Just a couple of months ago, I lost my oldest son. He was shot and killed in Gardere. The guy is set for trial. I end up talking to his family. And what I'm trying to say is that we all make mistakes. And prison was created to punish you and rehabilitate you. And I think 20 plus years, I think she have learned her lesson. And if you guys would grant her parole, family is strong. We will be united again and help her in every aspect that we could. So I just want to say thank you for giving me this opportunity to speak, and hopefully you guys can grant her parole. Thank you.
Sir, appreciate hearing from you this morning. All right, before we start the interview, we'd like to hear first from the opposition, and I'll let you guys, we have Miss. I'll tell you what, let's hear from Miss Mabel Landry, who's on Zoom first. Miss Mabel?
Good morning.
Morning. Go ahead, ma'am.
Yes, thank you this morning for allowing me to talk about this situation to you all. I'm speaking from my heart today when I say that I forgive Miss Flowers for what she did to my family. It was traumatic, it was heartbreaking, devastating, and I think the greatest form of aggravated robbery anyone could do. Because she robbed my family of a future that we would never know. She robbed us of a sister who loved her siblings, a mother who loved her children, a grandmother who loved her grandchildren. She robbed the church of a person who was deep into ministry, loved her pastor, loved her church. Matter of fact, the weekend Miss Flowers committed this crime, my sister was preparing a banquet for her pastor and the community at that time. She loved her community. She loved the people around her. She loved life. However, and I want to say that I'm from Atlanta, Georgia, and anytime I came home and was with the family, my sister never allowed me to talk about the Falcons. It was always the Saints. So I knew she loved her livelihood. However, I want to say that forgiving Miss Flowers has nothing to do with the views on this parole today for me. After listening to these testimonies, I'm just convinced that she's not ready to handle the privileges and the responsibilities of living outside a confined facility. I'm convinced that as the time that she thought she could do these kinds of things without any remorse. So, and I realize that it takes a lot for you all to consider what she's done, but I'm asking you to consider my family. Finally, I don't know if the judicial leadership of Iberville Parish have ever thought about how Miss Flowers was able to do these things. after doing some research on her, I found that she was already supposed to have been in the system. It was found that she had committed a numerous amount of crimes already. And so killing my sister wasn't her first rodeo. She had a pattern of what she did. It always involved breaking and entering, destroying property, using weapons of destruction like fire and bleach to annihilate anything that she went after. So in an effort to disallow her the opportunity to put other abiding citizens in jeopardy wherever she is, and to ensure that no other crimes like this one fall through the cracks, I'm asking the board today to allow her to remain in the facility where she's for the safety of herself as well as other productive citizens, because I believe with all my heart that she deserves a chance for rehabilitation and that it may enhance her ability to one day live as a productive citizen. My deepest concern is that Ms. Flowers receive all the time she needs to be fully rehabilitated, which will allow her to return back to civil society. I think the number of years given at her initial sentence was what was determined by the number of years needed to accomplish that goal. So my consensus is that only she could be returned to the society and be regenerated into the society after she's completed that time. After all, my sister was entitled to a life of freedom, peace, and happiness as well. Thank you so much.
Ma'am, Ms. Landry, thanks for speaking with us this morning. We appreciate it. Here with us, we have Dawn Urson. Okay, I didn't have him listed as speaking, so yeah, we'd like to have him. Morning. We need you to speak up, please, sir, so they can hear you.
I'm sitting here listening. She took my mom's life. They said she went back to her mom with just drawers. They said my dad took all of her money and her retirement. When my mom didn't even care about her. My mom knew what she was doing, didn't even worry about her. She was riding in my dad's car when my mama didn't even have a car. I was going from St. James to Platte to pick up her to bring her to work. I lost my best friend. I can't ask her to come back to live with me. But they want her to come home to be with me friend. You don't deserve to be out right now. You took a kid for 4 years, and I think that's what you deserve. Not a day earlier. And she went there for to confront her about why she's harassing her. Don't go to somebody out there at 6 o'clock in the morning, I pick and came a solution. Asking why you calling my phone. You went there with the intent of what you was going to do. It was already in your mind. You harassed her. You broke in my mom's home, went in her closet, and destroyed all of her clothes. But you want to have big pair of drawers in the church, no money.
Yeah, Mr. Wilson, we need you to address your remarks to us, not to Ms. Flowers.
I'm hurt. And I don't think that should be heard a second chance.
Thank you, sir. Ms. Urson?
My name is Dawn Urson. I'm Carrie Wilson's oldest daughter. I want to start by saying, I want to begin today by letting everyone know the violent crime that she committed. She was my father's lover while still legally married to our mother. She stalked and harassed him from March 10th, 2002 until July 13th, 2003. From breaking the locks and windows on the house, pouring bleach and red pepper on her clothes, in her closet, except our father's fire, having the lights and water turned off, calling her numerous times. The reason we know this is because my mother kept a detailed record of the harassment. She left a 5-subject tablet of the harassment, which was hidden in her car in a briefcase. We didn't find out the details of the harassment until my little brother went in the car and found the briefcase. Before she violently took my mother's life on July 14, 2003, she was on probation for 5 years for setting her then boyfriend's house on fire with him, his girlfriend, and his 80-year-old mother inside. See, she doesn't value anyone else's life. Her, Miss Flowers, she got into the house and watched my mother take a shower. She attacked her from behind while she was getting dressed for work. She was dressed in a bra, khaki pants, socks, and black shoes. She hit her in the back of the head with a black vase, leaving 3 massive lacerations to her scalp, as well as contusions on the left side of her forehead. She was determined to end my mother's life. Even if my mother had escaped Audrey's violent rage, she had flattened the tires on her car with an ice pick. I have my mother's autopsy. She stabbed my mother so violently with the ice pick, it went through her bare skin that tore through the layers of her heart. Also, her right and left lungs were stabbed 2 to 3 times each with an ice pick. Because of her rage and overpowering strength, my mother lost that battle. She stabbed her with a 6-inch knife and left it embedded on the right side of her neck. Her spinal canal, along with her first cervical segment, with only 2 inches left exposed. After my mother took her last breath, with her fingers entwined above her head, praying on her way out to meet her Lord. And my mother, she loved the Lord. She poured gasoline on top of her body and set on fire, with plans to burn the house down with my mother inside. She murdered my mother for my father, the $100,000 life insurance policy he had on my mother, and the new house they were living in. See, if she would have let my mother live in 2 weeks, just 14 days, she was leaving him after the family's vacation. She could have had my father and the house. She only knows how to be violent. So approving her for parole will leave everyone's lives in danger. We thank God my sister and my 2-year-old niece at the time wasn't in the house because she had threatened to kill them too. So she doesn't deserve probation. It was premeditated because she got everything she needed, the ice pick, the knife, as well as the gasoline.
Yes, ma'am. Thank you. Thank you for speaking with us this morning. All right, Ms. Flowers, would you answer any questions Ms. Ledoux has for you? Ms. Flowers, had you ever been involved with the victim in this crime before? Did you ever speak with her or have any interaction with her?
No, she just kept calling my house and I just kept calling her back. She harassing me too also. I just didn't harass her for nothing.
Okay, so she was bothering you.
We were bothering each other, yes.
So, what is it with the gasoline? Is that just an easy way, an easy tool to use whenever?
I didn't have no gasoline. She the one who had the gasoline. and I knocked the gasoline out of her hand.
Okay. Well, that's not exactly how the report read that I read. So how many violent crimes have you been charged with?
2.
Staff there answer a question for me. I understand she's level 3 in mental health. Would any of those diagnoses involve impulsivity?
Yes.
Can the warden, do you have any of the mental health issue there?
Looking for that sheet right now.
Okay. I can see level 3 care. Are you currently taking mental health medication, Ms. Flowers?
Yes, ma'am.
Yeah, with those 2 diagnoses, I wouldn't necessarily say there's impulsivity issues there.
They're not.
No, ma'am, not on these 2 diagnoses.
How long have you been in, Ms. Flowers?
Been here?
Yeah.
22 years.
32 years?
22.
22. Okay, that's what I think. Okay. Were you initially charged with first-degree murder?
No, ma'am. I don't think so.
Thank you. Okay. I don't have any other questions, Ms. Renaud.
No question.
All right. So let me ask you this. This is a rehearing for you, Ms. Flowers, and you were seen in 2023. You had a parole hearing and you were denied at that time. It said DA opposition. Of course, there was still strong victim opposition and there was law enforcement opposition, and all that still remains today. So tell us, what have you been able to do since that hearing in 2023? I know you have some health issues, but what classes have you completed since that hearing? Anything?
I took re-entry, I took parent, I took substance abuse, victim awareness.
Okay, so tell us what you got out of the victim awareness training.
I got a lot of it. When they show the film, you can't let people push you around. You just walk away and don't get involved, but they get involved in. You know.
I don't see any other questions at this time, Ms. Flowers. I guess the panel's prepared to vote. Mrs. Ledoux. The panel is charged with first of all, being concerned about public safety. And in this case, I am not prepared to grant. My vote is going to be to deny. I feel like we still have a public safety concern with the history of violence. Significant opposition. There was a plea agreement. So today my vote is to deny. Mr. Byron.
And I concur for the same reason.
All right, Ms. Flowers, and I do agree with my colleagues, and I agree to some degree with what was said today. And I just don't think you're quite ready. It doesn't seem like you really understand, you know, the seriousness of what it was that you did. And you need to have a better understanding of the impact that you had on the victims, which includes your family as well. And of course, I mentioned the opposition. We heard from it today. It's expressed in the record. So my vote today also is to deny your application. So good luck to you, ma'am. Thank you, Warden Thomas, for accommodating us. We're going to sign off. It's 9:36.
Thank you.
Denied.
You know, I don't know about you guys, but I did think kind of at the beginning of that maybe there was hope. But But that turned pretty quick for me. Anyways, so before we move on to the next court, let's talk about a subject matter that I've been covering a lot lately. Y'all know what it is, don't you? Right? Are you ready? It's Michael Groff, of course. Listen, what Michael does on YouTube is some of the best stuff I have seen. Yes, it is a little bit nichey. It is Arizona weather, though he does talk about some national stuff as well. But he is incredibly good at what he does. So, as a matter of fact, that Denied that you just heard was Michael Groff's creation. He also has an approved stinger for us as well when things go right, which for the inmates, which doesn't often happen in Louisiana, so we don't use that one quite as much. But Michael deserves your attention. Support the people that support the channel. If you are not already subscribed to Michael Groff, I'm going to drop a link to him into the chat. Go over there, subscribe to him, give him your attention. If for no other reason, then everybody who listens to him comes back and says, oh my God, his voice alone is the reason to watch his YouTube channel, and there's truth to it. Plus, you can also catch him on Sidebar tonight. He is one of the panelists on that show. We do that every Tuesday and Thursday, 8 p.m. Eastern, 5 p.m. Pacific, so you can check him out there as well. And Barbara actually just dropped that link. Thank you, Barbara. So again, if you're not already following Michael, go do that. Let's do this now. Let's choices. Let's go back to Judge Stevens.
547. Shalina Jovan Ziegler. And oh boy, I'm looking at the criminal history. It's a long one, isn't it? You're gonna get fixed though?
Yes,
Ooh.
sir.
All right.
Something come up, and,
Your case.
I mean, what do you?
Okay, we're going to talk. Let me just put something on the record here. You are Shalina Ziegler here with Mr. West, your attorney and the state's attorney. In this case, 25 DCCR 547. You were charged with the state jail felony of theft, and paragraph 2 is pretty prolific as far as theft convictions. I'm looking at how many theft convictions do you have? Your life, it's your life. You know better than anybody in the world.
Yes, sir.
How many do you think?
I think I have 14 and I'm now 17.
17.
17?
Yes, ma'am. I just counted 17.
Oh, I thought it was 14.
You thought it was 14. What does that say? Though, that I know something you don't know about your own life. It's too many.
I know.
You steal a pack of gum.
I know.
It's a felony. I think I've told you about it. That's why just, there are only 3 things in the whole world that really work for everything. It's live honestly, harm no one, give each person respect. Then life is good for everybody involved and those you touch, whose life you touch. Do you have children?
Yeah, one.
Well, that's, the great, what's the greatest gift you give your child? A good example, a good role model. Okay, but you can always start.
Make sure you don't go inside.
Yeah, you can always fix it. Do you want to do that?
You can have it.
Good. All right. So this is a state jail felony, which carries with it up to 20 years, up to 2 years. Oh, I got everybody's attention on that one. Up to 2 years in the state jail. It's serious, but Ms. Ziegler, I want you to be honest. Live honestly. Don't. You've had enough of this. You've gone off on that wrong trail for far too long. Let's fix it. Okay. What was taken here in this? 2 comforter sets? Well, that's all. They weren't cheap either, were they? JC Ponies. Okay. It's initial, so we're gonna, do you need 4 weeks?
Yeah, Your Honor, and there's, I was just informed earlier, there's another case that's incoming, it's the same offense, same type of stuff. So we need to get that in and work out a deal. So some time to negotiate and go over discovery, yes.
Okay. Are you committed to doing better?
Yes, sir, I am.
How old is the child?
He'll be 23 this month.
Okay, he's independent, living on his own or something?
Yeah, but he's,
But you have grandchildren?
no, I don't.
Okay.
He's broken.
He's what?
He's broken. I'm here and, it messes with me.
Well, your life touches other people. It affects other people. You don't live on this planet alone. And you gotta always consider your choices, how it may affect others who are.
And I want to see if maybe if I can, I went to the hospital in October. And I want to see if I can, check myself back in.
Or,
Middleton,
ma'am?
my mental.
Oh,
Mental status.
kleptomania?
What did you say?
Kleptomania? That's when people
So that.
steal, have
No, I'm
cannot stop themselves from stealing things.
Is that?
Well, you've got 17 convictions here
Is it?
of thefts.
Yeah, I went back in October and I was gonna go today and I got pulled over yesterday and they said that I had some out of Louisiana, so I was coming to court from the free world.
Oh, really?
Yeah.
That's why she's on this docket today. Today's a non-jail docket.
Okay.
She got picked up last night.
Okay.
Right.
Well, is 4 weeks good or less?
Yeah, we'll get the
4 weeks?
She Parish has also on it, something up there, so.
Okay, all right. We're gonna reset this and see if we can help you get on the right track.
Thank you.
Okay, yes, ma'am. All right, Barrett Bishop, please. All right, we now call two cases, right? 23C 429 and 23CR 430. The state of Texas versus Barrett Henry Bishop. You are Mr. Bishop.
Sir.
Here with your attorney, Mr. Galmore, and the state's attorney. Earlier, the defendant entered pleas of guilty to each of these cases.
Lesser included in each case.
Yeah. I was going to put the day. Same complaint.
Yes, sir.
So you were charged with the first-degree felony of sexual assault of a child. However, the defendant pleaded guilty in an agreement with the state to the lesser included attempted sexual assault of a child. And this is showing a third-degree felony.
I believe that's the way we filled it out, was a lesser.
Is that right?
Third.
Yes, sir.
But it was filed as a first.
I believe the family enhancement was dropped and then we did it as an
Yes,
attempted.
we did, Judge.
Third.
Is that what we
Yes,
did?
sir. We did. Yeah.
Okay, so everybody agrees
It's a third.
this was, the plan was he would be prosecuted for a lesser included attempted sexual assault of a child, a third-degree felony.
Correct.
Which carries with it no less than 2, no more than 10 years confinement in prison for each case. And the sentences, whatever they are, they're going to run concurrently.
That's correct.
All right, have the parties had an opportunity to review the pre-sentence report? Any corrections or changes?
None from the defense.
Not from the state.
It's made a part of the record for all purposes. The agreement, whatever sentence shall not exceed a year, a length of 3 years in prison. So on a third-degree felony, we are looking at no less than 2, no more than 3 years confinement in prison. And are other probations available?
Yes, sir.
If deferred as well as regular?
I believe both would be.
Yes, both would be available. Yes.
All right. who wants to state may open and close.
Sure, Judge. Judge, we fashioned this agreement because of the complaining witness's wishes. She spoke with me and
How
my
was the
office.
complaining witness?
She was
16 at the time.
15 to 16, I think, yeah. She was a child, yes, sir, and that's why we did it is the way we did it. But after speaking to our office now, she is in the military. She has thought about this long and hard. She spoke with us and wanted him to suffer some consequences, but she didn't want them so harsh that he would be taken away from his children for a long time or suffer any really bad consequences to keep him from being able to support his children. So I believe that her wishes are fulfilled in what we've fashioned because she seems to be okay with it. She's happy with what we're doing. And but we've still got a problem of this was a child, as the court mentioned. And so we've got to deal with the fact that there were some things that happened that took advantage of her being a child. And so this didn't happen just once, but happened, as you see, 2 different occasions.
It says multiple times.
Yes, well, yes, sir, but we've charged her with 2, so.
The first occurring when she was 8. According to this, that's been without objection.
Yes, sir.
In the pre-sentence report. This happened, so it went on to describe she would wake up and this happened at least 3 times.
The actual charges that we're having right now, Judge, is the 2 that when she was older as a teenager.
Everything gets rolled in.
Yes, I know, Judge. And the reason I'm saying this is because I'm trying to stay within her wishes. I'm not, I could be harsh and argue a lot of things, but she did not want us to be that harsh on this. So that's why we fashioned the plea bargain we fashioned. And I'm trying to fulfill her wishes. She's gone through a lot. And she also says that Mr. Bishop, once she became older, helped her get into the military, helped her do a lot of things in her life and tried to set things right in her words. But you can't set those right. And you know that, Judge, it scars a child for life what he did. So
yeah.
In that fashion, I would ask
what's the price of the loss of innocence of a child? Anybody know? Nobody can say. There is no price. It's morally and naturally and in our culture forbidden. I want to know. Because it's irreplaceable. From 8.
Yes, sir.
8 years out.
Because of that, but also because of the complainant's wishes, we'd ask for the 3 years prison time. I think that's something that's fair under what she wants and what happened to her.
Mr. Galmore, on behalf of the defendant.
Yes, Your Honor. Mr. Bishop is asking the court to consider probation for a couple of reasons. Number one, he is employed. And the reason why that's important is because he does have 2 minor children still at home. Those children, he does pay child support on, and he is actually paying. He's not a non-paying father, so he does help support his 2 children. And judge the impact that would have on them. We would ask the court to consider other measures that the court has at its disposal on top of the probation. He is going to be a sex offender for the rest of his life. And so I think that the stipulations are going to keep him, in the straight and narrow and protect society. Of course, that's going to happen regardless of which route the court goes. But at least if he were granted probation, he would be able to continue providing support for his 2 children. He has 2 children. The complainant in this case was a stepchild.
But a child of his.
Absolutely. I just making sure the court understood that he's got 2 children of his own and that he does still provide.
Anything you would like to add, Mr. Bishop?
He did make a statement to probation and it is simple.
Well,
it should be.
I just have
right into the defendant's version.
Yeah. It was I feel ashamed, regret. I'm trying to get through this to be for the kids. That's what he said. That's correct. Saint. This was originally filed as a first degree firearm. That's correct. And which carried with it the normal first degree. It wasn't an enhanced first degree. It was a regular first degree felony there at the beginning. So you were looking at no less than 5 years, up to life in prison. And the parties have worked in an agreement here that is below that minimum. But this is a multiple event. And the child was according to her statement to the police, this happened multiple times, with the first instance occurring when she was 8 years old. And that liquor was provided to the child during the episodes, alcohol, vodka. If nothing further, the court is going to find that the defendant has pleaded guilty to this lesser included attempted sexual assault of a child, a third-degree felony. That's correct. You have pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at your hearing. That's the sworn statement. And essentially, we call that the plea agreed confession and statement of responsibility. You pleaded guilty voluntarily, knowingly, intelligent. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this third-degree felony of attempted sexual assault of a child. And I'm following a disagreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. You'll be given credit. There's not any, there's 1 day credit, I think. That's all. But you'll be given credit for the time you have served. Also, because of this conviction, you must register as a sex offender. And I think on this, it's going to be for life. And that failing to register properly and timely can result in the filing of a felony offense against you. So that needs to be done. And that needs to be done, I think, immediately somehow before you, y'all need to work that out before you, or
They work it out in the prison.
What options they have up in the jail or the prison. I'm sure they've got something there, but if it's not, you don't want to be hanging out there exposed to potential criminal liability when that's unnecessary. You can, it's a 1-page document that gets filled out. I think it's, you sign on the second page, but it's a 2-page document. Do you understand what has happened today, Mr. Bishop? Fine. Y'all trying to put that back together.
You have a good relationship with my kids.
Well, I mean, talking about the child. Y'all have a relationship over
We've had a no contact order since.
Yeah.
Since it started, so.
Yeah.
She lives in another state in the military.
Okay. Well, I'm sensitive about families. Some things can't be fixed, some things can. It's fixable somehow. Family's a gift, natural and gift from our Creator. You want to make the best use of it for the betterment of the family unit. I hope things turn out better on this. I'm sorry this happened, but can't harm a child. That's forbidden, and it pays a high price. All right. Thank you very much. That is all. We're in recess. All right. We're getting.
So yeah, yet another one of these cases where we've got somebody who it would seem is taking advantage of a child. Interestingly enough, that's going to pretty much be what we're going to talk about on Sidebar tonight. So be sure to join us 8 p.m. Eastern, 5 p.m. Pacific. I will be posting that episode shortly after we're done with the live show here, so you'll be able to find it on the channel, and do join us. We have a panel discussion. We talk. We disagree. Sometimes we agree. It's fun. I haven't gone here in a while. Let's go back to Florida, but this is Judge Anna Garcia, who we haven't seen in a few weeks. She's doing her felony docket.
Number 24 CF 53. The court had previously given him a conditional release. He was released to someone's care to a particular home. That didn't work out. We've revoked the release, but there had been guardianship proceedings that had been instituted. And Ms. Simpson, were you working on the guardianship at one point?
I've been working on the guardianship and ran into this lady, and she said that she did guardianships and the present guardian was ready to get off. So
Are you somewhat of a professional guardian, ma'am?
Yes, ma'am.
Tell me your name.
My name is Olivia Baird. I've been a guardian for Baird, B-A-I-R-D. I've been a professional guardian for 17 years in Central Florida. In 2020, we moved to Jackson County, Washington County, and Holmes County. I'm originally from Holmes County.
How do you like living up here?
Well, I've come home.
Excellent. So this is home.
Yes, much better, a slower pace.
Ms. Baird, it's a pleasure to meet you. It's great to know that we have some local professional guardians that may be available. And so now you've been appointed to be his guardian, and you have an attorney from somewhere else, right?
Yes.
What can you share with the court, if anything, regarding the status of the guardianship proceedings and placement? The court will absolutely allow him to be released to a suitable placement. We just need him to be safe.
Okay. Well, Mr. Green and I met with him yesterday. He is totally confused as to what he wants, what we think is best for him. The chaplain at the facility has found a place for him called Promised Land. I have not been there physically, but I have looked it up online.
It is a drug rehab.
It is.
Yes.
Yes. So I think that would be a good placement until I can find a more appropriate placement.
Sure.
He does not want to go to either place unless he spoke differently with Mr. Green after I left. But I think it would be an appropriate place to get him out of the facility that he's in now.
Is it ultimately your desire to get him to some sort of APD placement?
Yes, ma'am.
Got it.
Yes.
And I know that takes a second.
Yes, yes.
Yeah. So is that
Yes, that's correct.
basically the update?
Talked with the chaplain. He has spoken with Promised Land, who was willing to take him. It would give him a little bit more structure than he had in the last place, and hopefully will be a non-jail placement for Cameron while we're trying to find him.
While we figure out with APD. Okay. All right. Well, anything that we can do to support and assist, let us know.
As far as the funding, do we come back for a guardianship hearing? Judge Patterson?
Yes, he's our guardianship judge.
We're actually going to be filing a motion after talking to her attorney yesterday. We're filing a motion so that she can open up a guardianship account for Cameron McClendon. And so the money will be given to her, hopefully, if the judge approves it, to a guardianship account. It's been sitting in my trust account. We did an accounting and everything for the judge.
Okay.
And I think that
Because
way
he does
she'll have
receive
the
some benefits. And so
He
there is.
was, I'm not sure that any of us currently know his social security number to help get him some more benefits, but we've got to find that number.
Give me 1 second. Ladies, do you have social security number in your court files through all of the different, either whether it be criminal or otherwise? And without putting it on the record, let's write it and give it to Ms. Simpson.
Oh, good, they got it. Yes. Can y'all write it, huh? Write two, so she can have one and I can have one.
And the court is ordering the clerk's office to write it down for them so that you guys are clear, ladies, because I know that you're not allowed to give out personal identification information. Hopefully that's it, but maybe that's it.
Okay.
That doesn't look right to you?
I thought he was born in Florida. This is not a Florida social security number, but I'm not sure where he was born, Your Honor.
Were born in Alabama.
So he could.
Oh, yeah. Is that in Alabama? Does what?
First three, yeah. I was.
But I'm an old person from.
We were all there. We're all there, my girl.
That's okay.
All right. So that's where we are with Cameron. Do you want to set him in a week? What do you want to do?
If I prepared in order, Promised Land, is that something you'd be?
100%. I mean, does the state have any objection to that?
No, none, Your Honor.
None at all. So I'm happy to simply continue a conditional release to Promised Land, and then whenever the APD placement comes in place, and then you wouldn't want any continued, or do we just do a 6-month court date? This is ultimately going to be a dismissal for non-rehabilitation, right, guys?
Correct.
All right. So when was it filed?
The information,
Mm-hmm. Because what do we have to do? 3 years or 5? I can't remember.
I think due to the nature of his disability, it's 3, but I will double check the statute. It was filed in 2024. The exact date is
So do you want to set him for maybe March of 2026? Do we have those dates, ladies? Let's guess at the date. Debbie's listening and she'll tell us, but she'll tell us if we're wrong. I think the March date is that's an arraignment. We could do a pre-trial. It'll probably be either March 10th or the 17th. And we can do the afternoon.
It will be March 10th.
No, that's
good for regular.
March 10th. Yeah, because we try to stay away from spring break. So March 10th, 1:00 will be the continued court date for Cameron. And hopefully we've got some good news. But if you need us, Ms. Baird, before then, anything that the court needs to do to amend its conditional release to make it so that he can go to an appropriate APD placement, just please let Mr. Green know and we'll take care of it.
All right.
All right. It's good to meet you.
Same here.
All right. Does that take care of all your cases? Okay. All right. Thank you, Mr. Green. Thank you, Cameron. Bye. Yes, sir. You can ask Mr. Blunt.
Case number 20.
Okay, I'll keep an eye on her, see if she brings up another interesting contestant at some point. In the meantime, let's go to Wisconsin and Judge Mogan.
Record in the matter 24 CM 12025 CF04, State of Wisconsin versus Littrell Paffel. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Paffel, who is appearing by video conferencing in custody in Burnett County Jail. His defense counsel, Eugene Harrington, appears in person. We're set today for status conferences in these cases. The court has received a request for a speedy trial as it relates to the felony matter. So we would need to be setting that matter for a speedy trial. As it relates to the 24 case, the misdemeanor case, Mr. Harrington, do we have an update on that?
That case is settled.
That is settled. And so are we going to take a plea today?
Not today. Mr. Schmidt and I are still chatting about proposals. I had one, and Mr. Schmidt pointed out that it won't work given what he wants to accomplish. So I just have more work to do. From the speedy trial perspective, Mr. Schmidt and I are reasonably sure that Winquist is going to be resolved. That is scheduled for 10 days of jury on the 20th of October.
All right. And to be fully candid, Mr. Schmidt, I've been getting a lot of speedy trial demands for whatever reason. And at the last hearing this morning, when I needed to schedule another one, Mr. Schmidt said the same thing. We're reasonably sure that this could proceed. And he said, we'll wait until, I think I hear on the 14th.
I'm here on the 14th at 9:45.
And so we'll get an update unless you want to move that date to another date and time, but then
Neither of us are putting the cart before the horse. Obviously, we're gonna ask the court first.
Yes.
Yes, no, I understand. I just didn't know if you wanted a different time to be heard on that. Because I can't remember.
My calendar says that Windquist is scheduled for 9:45. My next status after that is 10:30. And I've got Oyette, Capitone, Chapman, Bruss, all at 10:30. Oyette, I'm reasonably sure is going to be settled. Capitan is going to be settled. Chapman will probably be settled. Bruss has been settled. That's been consolidated in Polk. We just have to get the certified copy of the JOC there. And you have it. So we're good to go there. I need to find out how many jail credits that the Polk County clerk needs to add to the judgment of conviction.
Okay. All right. With regards to this case, and what I'm hearing is you're thinking that it may resolve, it may have a better agreement in the public interest. So you would like to potentially double book that time? Since it's already, yes, with Pathel.
Book the trial for October?
Yes.
Yes.
Okay.
Stack it. That makes sense to me, Judge.
Let's do that. Let's focus on the second week. October 27th through October 31st.
That's not gonna take that long.
No. So how many days do you think we need?
If it takes two, I'll be surprised. Agreed?
I was gonna say it's not gonna be a long one.
A 1 day, which day out of that week do you want? Unless you want, I don't want to, the jury's it's gonna be the same jury pool, but if the other matter goes and when Windquist comes off and my other case goes, then we're gonna have a 3 day the week before. So we probably shouldn't have a jury for 2 cases.
Even if Windquist were to go to trial, that's not gonna take 10 days.
Okay.
So that second week, my grandson's birthday is Friday, the 31st, so I'd prefer not to have a trial that day.
What about Tuesday, the 28th?
Perfect.
All right, so we'll schedule it for Tuesday, October 28th. Now, I'm just questioning, just so I can stay in the loop and have my head wrapped around this matter. Is there a possibility that the felony matter could resolve? Or, okay, so you're still gonna be in strong negotiations?
I'm gonna go back to my office in Shell Lake and sort through what it is. Mr. Schmidt has told me what he needs to resolve the case, and actually, Mr. Pathel has told me what his preference is as well. I'm gonna try to accommodate that, and Latrell and I will chat probably again on Thursday.
Excellent. And if I recall correctly, it's approximately September 11th or 12th that he is done with his revocation.
Something of that sort, yes.
Okay. All right. So, Mr. Pathel, we will see you. Well, we set the trial. We need to get another date. Do you want a status? Or would you just like to have that final pretrial for Latrell?
I'm not sure how far before the trial you want the final pretrial. My suggestion is, why don't we just have a status for 28th of August. I'm here at 2:30 on a motion hearing, although that I don't think is going to take very long either.
All right, so let's schedule you for August 28th. And I don't know how long that hearing is scheduled for. 2:30
Judge, that,
for half an hour.
that isn't gonna take very long. In all honesty, after looking at Mr. Schmidt's motion, when I read the complaint, I missed something.
Okay,
So
so why don't we do 2:45? We'll do 2:30
2:40.
for your motion hearing and 2:45 for Mr. Apple. August 28th at 2:45. All right. Nothing further, then we are adjourned.
Thank you, Judge.
Thank you.
Okay, let's bounce back to Louisiana and we'll give them another try, see if we have a denied or an approved.
Good morning, Mr. Reed.
Good morning. How y'all doing this morning?
Good, thank you for asking, sir. Tell us your name and DOC number.
Herbert Reed, DLC number 474321.
Yeah, 474-321.
21.
Yeah, 474-321. That's what I
Yes,
got.
ma'am. Yes, ma'am. That's it.
So, Mr. Reed, you're here for a revocation decision this morning. I see you brought in some paperwork. Do you have your parole revocation questionnaire there with you?
Yes, ma'am.
And is that your signature at the bottom of that page?
Yes, ma'am.
Based on your answers to those questions, it was determined at that time you're not eligible for appointed counsel. So are you ready to proceed this morning without a lawyer?
Yes, ma'am.
All right. So your case this morning has been assigned to Mrs. Ledoux. She's going to read the allegations against you, take your plea, and then have a discussion with you. Before we do that, I want to let you know we have some folks here with us who want to speak in support. We have Crystal Turner and Ms. Dolores Reed, and we'll hear from them in a few minutes.
Okay. Yes, ma'am. Thank
you.
Good morning, Mr. Reed. I'm going to read out the allegation. I need you to enter a plea of guilty, not guilty, or guilty with a statement. Okay?
I can plead not guilty with a statement?
Yes, if you would like. I'm going to read it first, though. Okay? You're accused of violating condition number 4 in that you failed to refrain from criminal activity, being arrested on 1/1/2024 for the violation for domestic abuse battery.
Yes, ma'am.
And on 6/10/2025, the charge of domestic abuse battery 4th was dismissed against the accused. And the court ordered that the accused be released from the bond obligation from this charge only, and the protective order is dissolved. How do you plead?
Not guilty with a statement.
Okay. So you were arrested for that offense, and it was dismissed.
Yes, ma'am.
So what is your statement?
My statement is, I'm for the charge. I pleaded not guilty because I really didn't commit the charge, but as I take full responsibility for me catching the charge while I'm on parole.
Well, what were you responsible for? So did you?
I'm responsible for catching another charge while on parole.
Okay. We're going to go ahead and I'm going to listen to your mother and Miss Turner. Miss Reed, if you would like to step to the podium and address the panel and tell us what you would like to say.
Yeah, questions from the audience.
You just tell us what happened and what you want to say about your son.
Well, I called the police for him on January 1st. We were arguing. And maybe I went too far because we was arguing and, going down the hall, it just was a little bump, but I was so angry with him, I called the police. And I just told the police that to take him away, just get him away. But they took him to jail, and I told them over and over, I didn't want him to go to jail. I just wanted him to leave right then because I was angry. But then they still took him to jail.
How many times had you had to call the police before?
For me, that was the first time. That was just the first time.
Okay.
I mean,
Okay. I don't have any questions. I don't have any questions. Ms. Turner?
Good morning, my name is Russell Turner. Herbert Reed is the son, is the father to my son. He's 11 years old. He's in need of I really need him home to help me with my son. I'm a single parent of that one child. And he really helps me out a lot with him when I'm at work or when I need him on the weekends, and he was working to help me down with child support to help me with the child. So at the time of him being arrested, he was doing very well when he has, accomplished in the past as far as his job and everything related, because child support was holding back for a lot of years. I've been with him 12 years. So that was like the best that he was doing as far as his mental health, his physical, trying to constantly push himself, even though he was being taken advantage from ours. The money was getting away from the shake, but he was still pushing himself every day at work. So I just really need his help at the moment.
I had a question. Did you ever have to call law enforcement to intervene in any situations?
In our first year of our relationship, yes. But after that, he started trying to do better as well as working on himself. So I know he did classes one time a couple of years back for something, but that's about it.
If y'all were having a great home life, how come he was at his mother's house causing trouble and not at home with you?
Because at the time we had separated, September 3rd, we had took a break from each other to see if we wanted to head in the direction as far as marriage, because he gave me an engagement. I want to see if that's our next step as far as if that's what he was ready for.
So y'all separated at that time because he gave you an engagement ring?
No, he gave me an engagement prior to that, but
And you wanted to see what
something
it was like
that I want to make sure he was adding up before, we contemplate things that was actually in the process of getting the house.
So there was no problem with y'all relationship when he was at his mama's house? That was just.
No, I would go over there all the time. No problem. I would bring a shower every weekend.
Okay.
Thank you.
Thank you.
Mr. Reed,
Yes, ma'am.
you're a third felony offender. How many arrests have you had for domestic abuse battery?
I done had a couple. I done had about three for domestic, about three.
The night of this particular incident, were you, had you been drinking?
No, ma'am. No, ma'am. The police actually woke me up. The police actually got me up out of my sleep. I actually was asleep. I actually had thought that everything had calmed down, and I had went to sleep. And when I woke up to the police asking me to leave, and I was still kind of asleep because they came in the bedroom and actually woke me up. And once I got up, I was still kind of sleeping, and they asked me to leave, and I kind of refused to leave. And when I refused to leave for them, they just got tired of keep asking me to leave, and it was New Year's. It was kind of cold outside, and I kind of didn't have nowhere to go at that time. So I kind of refused to leave from the police officers too. And once I refused to leave, they said, they kind of escorted me out and said they had no choice but to put a charge on me, and they went ahead and put domestic on me. But they gave me over, no lie, they gave me over 10 times to leave, but I was just waking up, and it was New Year's. It was kind of cold outside. It actually was freezing. And, I kind of refused because I knew I'd stay there, that's my address, and I refused to leave from the police. And they say since I refused, they had no other choice but to lock me up.
It said, the police report is a little different than what you're saying. Okay. And it is a sworn statement. I have to go with what it is. Maybear was obviously heavily intoxicated. They had already been there 3 times. It does not, she was not comfortable with you being there. And on other occasions, when she asked you to leave, that you would always go back because that's where you lived.
Yes, ma'am.
I read that. Was there a protective order against you? during that time?
No, ma'am. No, ma'am. I didn't have a protective order at that time.
That you haven't had in the past?
Yes, ma'am. Yes, ma'am. I did have one in the past.
Have any,
I have a question. The information we have, you mentioned, you were asked the question, how many times you've been arrested for domestic abuse? You said 3, you think 3, it would be 4, I think, with the one you have.
Yes, ma'am.
But there was, and you've been with Ms. Turner since 2014, 11 years?
About
Something
that, about 12, about around there. That's about to give big time.
So I do see an arrest in 2014, I see an arrest in 2020, and I see an arrest in 2021, all for domestic abuse. Who was the victim in 2020?
In 2020, I think the same one. I think I only was me and Miss Turner. You know, we had a history of domestic. You know, but you know that's why I took it upon myself. That's why, like she was saying, we took a break. You know, to see can I get myself together, and I was at that point of getting myself together, and you know, getting a job. You know, getting alcohol free. I was just I was on the right path this rip. You know, I do have a lot in my past that that I was coming back from. I mean, but I tried my best, and this time before this arrest here, I really had it going. You know, I had my job. I was getting back used to, scribing. I'm educated. You know, I have my high school diploma. Plan on going. I'll get back in college, get back in school when I make it back home. Do a little offshore work. You know, I have other kids other than Haven. I have Haven for her, but I have 3 other kids, and they need my help too out there. I'm just getting back on that path. I'm 40 years old now, and it's just time to let the foolishness behind me, and it's time to, it's time to get this life, and I'm willing, if y'all give me the chance to catch it this time, I promise that's what I'll do.
Okay, I have no other questions.
Mr. Reed, are you currently on parole? You were paroled by this panel?
Ma'am?
Were you paroled by this panel?
I don't know. I was paroled. I don't know, ma'am. I never. This is my first time ever been in front of the board.
Okay.
Yes, ma'am. But if I can get that chance, it's really, I really have, but just like I said before this time, I really had my grabs on it. I had to start, paying my child support. I had to start, really being that father figure. I'm just catching everything. I know I might have a past that I'm not very proud of. But I'm catching it, and I got it if y'all give me that chance.
Colleagues asked you about being on alcohol at night and causing trouble, and you said no. What about any other drugs? Do you use cocaine, marijuana, any of that other stuff?
Yeah, I use marijuana. And in my past, I have had dealings with drugs, but I was just like I say, I was at that point in my life where it was just really marijuana, and I did use marijuana. But before the past, in my past, I have used pills. But all that was over this rip. I was going through that back in 2000, 2001, like around that time, I was going through that change in my life.
And also in September of 2024, when you tested positive for cocaine, which probation was.
Yeah.
That's the only question I have.
All right, I think we're prepared to vote. Mrs. Ledoux?
Mr. Reed, you haven't been complying with conditions of parole. Whether or not this was dismissed, there have been problems with your behavior while you have been on supervision. You had the positive drug screen. I believe you were drinking that night and were probably drunk, which is also a misuse of alcohol while you're on probation. My vote today is to revoke your parole. I think until you have some the treatment, that, you're not going to, should we do the? I mean, perhaps you can go to, I'd like to put on here, go to a facility where there's treatment available, okay? So that you be placed in a facility where there is treatment. So my vote is to deny. Mr.
I'm gonna concur with Mr. Adu for the same reasons and also recommend that you be placed in a facility where you can get some help for your domestic violence, your anger management, and your substance abuse. So that when you do come up for parole on this, again, you'll be able to be considered for release.
My vote today, Mr. Reed, also is to revoke for the same reasons. You need some treatment to help you deal with the substance abuse and domestic violence issues. You had the positive drug screen, and again, I believe you were intoxicated at the time of this arrest as well. So good luck to you, sir. We're going to make the recommendation you be moved to a facility to get you the treatment you need before you get out again.
So my parole is revoked? Yeah.
Denied. So I will say on last Thursday's episode of Sidebar, we discussed this parole board and kind of how they handle things and whatnot. And I think the conclusion that we came to at the end was it's a really tough job. But if you haven't checked that out, please do go find it. It's on the channel. Again, it was last Thursday night, the last episode of Sidebar. Give it a look. It was a good discussion. Hi, Ellie. Can I see my screen so I can figure out where we're going next? Have a seat. Sit down. Good girl. Thank you. Let's go back to Texas and Judge West.
It alleges you committed the third-degree felony offense of assault on a public servant, and that is from August 19th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? See state tenders number 1.
No objection, Judge.
It's admitted. Mr. Falk, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent, you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a public servant, third-degree felony. Sentence you to, in accordance with your agreement, to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. See, Mr. Lewis, you have Kevin Tran. It says it's locked. Thank you, and bless you too. I know. All right, are you Kevin Tran? And Mr. Tran, in clause number 2137560, 2138780, 25 DCCR 0422, 25 DCCR 0423, 25 DCCR 0424. I'm going to take judicial notice of the files in all of those cases. Looks like the first two cases, he's on probation, and then we've got new offenses as well. Mr. Tran was evaluated for competency to stand trial by Dr. Grappon. I received that report dated July 21st of 2025. The finding in that report is that Mr. Tran is currently not competent to stand trial and that inpatient restoration would be called for. Is there any other evidence with regard to competency?
No, Your Honor.
All right, then based on that report at this time, I am going to find that Mr. Tran is not competent to stand trial, find that inpatient competency restoration is required, and order that he be sent to the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility, and then we'll await a report. Mr. Tran, we're going to try to get you some help so that you can understand everything that's going on, and then we'll get you back in court as soon as we can. You can go back with the bailiff. And then you've got a Michael White. Let's see. He's already been and come, now he's back.
He's back, but he's not, he's still, they don't believe he'd be able to be restored. He's going to be able to be restored.
Okay. So.
You guys had extra insurance, that's right.
All right, you're Michael White. And this is cause number 24, DCCR 0782. And Mr. White was previously found not competent to stand trial, sent to the Dunn Behavioral Science Center, and we received a report from them dated April 4th of 2025. That report is from Samantha Guzman, and the opinion in that is that he is still not competent to stand trial, with the finding that outpatient competency restoration could potentially be something that would work for Mr. White. The problem with that is that we don't have an outpatient competency restoration program. And so, and that he's not likely to achieve competency. So I don't know exactly where that leaves us, Mr. Smith. What's the?
Judge, I believe his mother lives in Florida. She's willing to take custody of him. And I believe they have a program that is along the lines of this with outpatient competency restoration.
Yeah. Would we do that through a civil, or would it be a dismissal?
That was the question I had on you. We're willing to do whatever it takes to get him there.
And Judge, if I may, I've been talking with his mother. She's been in contact with the probation department there, just trying to get familiar with what kind of programs they have. They have a program there called the Gateway Program that works with their mental health department. That's basically similar, goes along parallels to what this would be. And the only issue that they've been having to try to get information on Michael is, from my understanding, they can't do the interstate contact without it having an out date or anything from when he would be getting out to leave to go down there.
But I can't. Is this a motion or is this a new case?
It's a motion, because he was sent back from ISF, Judge.
Yep.
Okay.
He was sentenced to ISF as a term and condition of the probation term.
Mm-hmm.
He got to ISF and then started to regress. Right.
So I can, without pleas of true or not true, really, I think on that motion, I think we can just order that he live in a certain place, which would be with her, that he participate in those programs, and then the probation could transfer to that, correct? I mean, we can't do obviously any kind of pleas on anything,
No,
so
I
it would
agree.
require a dismissal of the motion to revoke.
I don't know, do we actually have a motion filed? I believe we just had this set for hearing because he was returned from ISF.
Gotcha. Okay, so then we just need probation to do the, I don't know if you would necessarily take an administrative hearing or just send in me the, order to sign, ordering the gateway program through, and if you can get the county and the address of it, where his mom lives, and you get all of that.
Address and that information this morning, so I
You can get all that to probation. Does that sound like something we can do? Okay, well, let's do that then. We'll just, not go forward with anything, motions here. Let's just, whatever conditions you need to add with regard to him being able to go there. And then we can kind of figure out when that's gonna happen so that they can get transportation. So if you'll work with probation, y'all get all that worked out.
Okay.
Okay?
No problem.
All right. We're gonna get it where you can go live with your mom in Florida, okay? But you still have to follow the rules. Oh. I don't know if that's a good thing or a bad thing.
He's gonna give me life.
All right, I haven't showed you guys anything animal related in a couple of days. This is from Tiny Kittens HQ, and they have some tiny kittens. Got one up in a window, one's resting, and then in a windowed camera up in the corner, it looks like another one's resting, another one's playing. So they're cute, tiny. I remember when ours were tiny. They're not so tiny anymore. If you were with us for the pre-show, you saw a picture of them a year ago. They don't even look closely the same as what Io and Ellie look today. So they do grow up, that's for sure. So most of the courts I've been monitoring have actually gone into recess. There's Judge West, and then there's the parole board. And pretty much everybody else is taking a break. Let's do one more from the parole board real quick, and then we'll probably finish with Judge West's court. But let's go to Louisiana.
Oh, you're on mute. Let's see. He's gonna turn it off. Turn it on, rather.
Well, good morning. How you doing?
Thanks for asking. Tell us your name and DOC number.
Clifton Edwards, 726-125.
Mr. Edwards, you're here today because it's alleged you violated the conditions of your parole. Do you have the parole revocation questionnaire there in front of you?
Yes, ma'am.
That's your signature at the bottom of that page.
Yes, ma'am.
Based on your answers to those questions on that questionnaire, you're not eligible for an appointed lawyer. Do you wish to hire a lawyer today?
I don't understand, ma'am.
You're not eligible for us to appoint you a lawyer.
Yes, ma'am.
And so if you wish to have a lawyer today, you'd have to hire a lawyer. You can do that, or we can proceed today with the proceedings. It's up to you.
We could proceed, ma'am.
All right. So I'm going to read the allegations against you, Mr. Edwards. You'll enter a plea of guilty or not guilty with or without a statement, and then we'll talk about it, okay? Before we read it. So you're accused of violating condition number 3, and that reads, in October of 2024, Officer Joan attempted to make contact with you at your residence of record without success. So how do you plead to violating condition number 3?
I take full responsibility for it, ma'am.
Okay, you gotta say guilty or not guilty, and you can say with a statement, and then you can explain it in just a minute. So which is it, guilty or not guilty?
I plead guilty to it, ma'am.
Okay, I'm gonna put guilty with a statement, and we'll talk about it in just a minute. Let's finish reading the allegation. Condition number 4, on January 16, 25, you were arrested for an offense that occurred September 26 of 2024. You were charged with domestic abuse battery and domestic abuse battery with child endangerment. On May of 27th of 2025, those charges were dismissed. So how do you plead to violating condition number 4, which involves criminal activity?
Oh, I plead not guilty to that one, man.
And then lastly is condition number 10, and it says you're behind on your fees, $665. Now, how do you plead?
I plead not guilty on that too, man.
Not guilty?
Yes, ma'am.
All right. So tell us about why you weren't at your address. You said you're guilty with a statement. Give us that statement.
Well, like I said, I take full responsibility for it. It's my first time on parole. I ain't know the seriousness of it, but when I got into it with my girlfriend, which was it was verbal more than anything. I had left her house and my parole officer, he come see me like every 3 months. So within that last month, I had left her house and I was waiting for him to call me up there because he normally called me every 3 months. So like I said, I ain't know the seriousness of it. I was gone from her house for probably a little less than a month, and I was waiting for my parole officer around that same time to call me, and then I was gonna go to him and change my address.
Why didn't you think to call him? You know, you can call him. The phone works both ways.
Yes, ma'am, I know, but that's why I say I take full responsibility for it. I ain't know too much the seriousness of my actions.
All right, tell us about the number 4, about the domestic abuse charge. What happened?
Well, I was falsely accused for that, man. It was just like my girlfriend, we had an argument, and I told her I was just gonna go on with my life. And I got a daughter, I got a 1-year-old daughter, and she know about my 1-year-old daughter. So I was really gonna go back home to my 1-year-old daughter and my baby mother, and she knew that. So out of spite, she called the police on me knowing that I was on parole and I can go to jail. But my innocence was proven in court. Then the DA called her and they talked to her and she told them the real story and she was like she not coming to court, she not pressing no charges. So my innocence was proven in court.
Yeah, is that the same lady we were speaking about just now that kicked you out of the house?
Yes, ma'am.
Same lady.
That's the same lady. Well,
What's her name?
Randisha Brown.
Okay. Who's Tranisha Chambers?
Tranisha Chambers, that was my arresting officer.
Okay.
Well, she took me to go get fingerprinted.
Okay.
And so you said you were not guilty of being behind on your fees. You're up to date?
Ma'am, well,
Arrested?
well, I had a job. I paid, and then I had lost my job. And my parole officer, he told me that it was okay, like I needed to just catch up on it. And this is another thing I wanted to state for the record. They switched my parole officer 3 times, and I didn't even know about my last 2 parole officers. So I really ain't know about my last 2 parole officers. I thought I still had the same parole officer the whole time, but they switched them out 3 different times. So my
And so how much are your fees each month?
like $74.
So you're about 9 months behind.
9 months, yes, ma'am. Cause when I first came home, I was paying. I had a job, but I broke my wrist, and I couldn't. I had to wait till I could find another job. With my own background, it's kind of hard for me to get another job.
What was the job where you broke your wrist? What was that?
Well, I didn't break my wrist up, but I was working at Waste Pro.
At where? Say that again.
Waste Pro.
Oh.
Yes, ma'am. And I was working for Sushi Maza on Perkins. It's a restaurant, a Japanese restaurant.
Why do you think we should not revoke your parole today? You got an excuse for everything.
Well, I feel like I take full responsibility. I just really need another chance, man. I ain't gonna make too many excuses. I got my children. I know everybody say they got children, but I got my children. My last baby, she 1 year old. I feel like I really ain't had enough time to really, be great. I ain't really had enough time. I had this time to sit and think about a lot of stuff. I came with my folder. I got plans. I graduated, so I like to go back to school. And I done took these classes, and I got a lot of certificates.
You
I
took
just,
the classes there at East Baton Rouge?
yes, ma'am. I got all 3 levels of the MOVE program, and I got certificate for seeking safety.
Okay, so let me ask you another question. Who is Frederica Johnson?
Frederica Johnson. Oh, that's my baby mother. My baby mother. My 1 year old mama.
And didn't you and she have some problems?
One time that was like we never had no physical altercation. I had got wrote a summary because we had an argument, but that was way last year, and she just called the police and told them that she don't want to send me to jail, to just that I'll just leave her premise. Cause I was trying to get my social security card. She had my social security card, my birth certificate, and my ID, and she ain't want to give it to me. So she ended up calling the police, and I was like, "Well, call them, and I'm gonna just sit here and see if I can get my stuff back." But when they came, they said I had to file some type of stuff downtown for to get it back, and I couldn't get it. So he told me to just leave. I don't really think he just jogged it down for the record. He ain't even write no summary.
What's your plan whenever you get out of jail? What you gonna do? Obviously, you can't go with either one of these people.
Well, I got some to say, man.
Where?
My cousin.
Where's that at?
My cousin, he stayed off of in Shenandoah.
They got any women living in the house?
No, ma'am.
Good. Is he on parole?
No, ma'am. He don't got no record. But like I said, I graduated, and I didn't know I could go to any college I wanted to go to with a high set diploma. But I got a high set diploma. I like to go back to school, and I like to go back to school, and I like to go take me a trade up for graphic designs. So I like to do graphic designs. I'll get bored and just get in my phone and go to making like posters and cards and stuff. So I want to go to school and take up graphic designs. And other than that, I just take it slow. I go find me a job, like some maintenance work or something, until I get myself together. Cause like I said,
All right, listen, Clifton.
yes, ma'am.
You just said something very important. You play with your phone. So next time you need to tell your parole officer something, you call them. Don't wait for them to call you.
Yes, ma'am.
And it's up to you to, you keep up with who your parole officer is. Listen, I'm, I was concerned, but I read all the record. There's a lot of mitigating circumstances. What is your contact now with Frederica Johnson?
We were talking about our child, but we not back in a relationship. It's just strictly on co-parenting.
And what is Rondisha Brown? What about that relationship?
Well, I haven't talked to her since that day.
Okay. All right. Listen, I don't know what my colleagues will do, but I'm prepared to vote. My vote today is going to be do not revoke. We're going to reprimand you for getting in the trouble. You pled guilty to leaving the residence and not informing your parole officer. But I want you to report that you got to go live with your cousin.
Yes, ma'am.
And report to the Day Reporting Center in Baton Rouge. They can help you work through whatever certificates you got and help you get in the school program you want and give you anything that you need to be successful.
Yes, ma'am.
And when if you get out now, I'd like you to report to your parole officer every week. It's your responsibility to report every week for at least 60 days.
Yes, ma'am.
Janae, your parole officer. I'm just one vote, so that's my vote. Mrs. Ledoux?
Mr. Edwards, you spent about 8 months incarcerated and the charges were dropped. There has been no contact with the victim in that crime or a victim statement or anything of that nature. I'll concur with my colleague, do not revoke, with the same stipulations of going to the day reporting center, which by the way is an excellent resource if you use it and you try. If you
Yes,
apply,
ma'am.
it's a good program. And that you have more frequent contact with your parole officer.
Yes, ma'am.
I'm gonna go ahead and concur with my colleagues on this one also, but note for the record that this case was dismissed due to lack of evidence and the victim wanting to drop the charge.
All right, we're giving you a shot. Good luck to you.
I appreciate y'all so much. I won't let you down.
Okay, good. We don't want to see you again. Not this way.
Yes, ma'am.
All right, good luck.
All right, appreciate you.
Approved?
I know you was.
Weird. I don't often get to use that stinger, but good on him, I suppose. Hopefully they never see him again and he never sees them. Let's go back to Judge West and we'll spend a few minutes with her to round out our day.
That would enhance him that are not required under law, if that makes sense. Jurisdictionally, they're not required, but.
Let's see. So it looks like there's two. The first two are, well, we've got a.
So he received 5 years TDC on the 93 case and then 90 days on the 98 case. And then my position is that at least that 2004 or the 2009, whichever this court would like to recite, would enhance him from the third to the second.
So he'll plead on all, let's say, except for that last one, because that would actually enhance it again. All right, so you'll waive the March 3rd, 2009. We won't go on that, but everything else. Does that make sense to you too, Mr.
Yes, ma'am.
Parker? All right, sir, are you Alfredo Gayton?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
He will, Your Honor. I gave you. Okay.
I think so.
Yeah,
I think I already signed it and
Okay.
handed it over. Give me just a second to get this pulled up. Mr. Gayton, in cause number 25 DCCR 0184, you're charged with the third-degree felony offense of driving while intoxicated, third or more, and that's for March 30th of 2024. The indictment alleges you were previously convicted of driving while intoxicated September 28th of 1993 in Harris County, Texas. And then after that, and then on July 9th of 1998, convicted of driving while intoxicated in San Patricio County, Texas. And then after that, you were convicted on July 28th of 2004, again in Harris County, of driving while intoxicated. And how do you plead to that charge? And are those prior convictions true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, sir.
And because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a cap of 14 years in the institutional division of the Texas Department of Corrections. I want to make sure you understand you have an absolute right to have a jury come in and determine two things. You could have that jury decide if you're guilty or not, and then you could leave your punishment up to that jury if they found you guilty. If we go forward this way, you're waiving that right, and you're leaving your punishment up to me. And as long as I don't give you more than 14 years, then you're waiving any right to appeal. Do you understand? Also, do you understand, if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Gayton is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Parker, and he'll present it to me on your behalf when we come back. All right? You can go back with the bailiff. Thank you. Sean Harley, Mr. Parker. Huh? Oh. Okay.
So I wouldn't be surprised if he changed his mind. He said he wanted to change his mind, but then he got to change it. He change it back.
Good morning. Are you Sean Harley?
Yes, Sean.
And Mr. Parker, will your client waive a formal reading of the indictment in each case?
You will, Your Honor.
Mr. Harley, in cause number 24-2148, you're charged with the state jail felony offense of criminal mischief, and that's from August 28th of 2024. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
And then in cause number 25 DCCR 0739, you're charged with a third-degree felony offense of harassment of a public servant. That's from August 28th of 2024. And how do you plead to that charge?
Guilty, Your Honor.
Again, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And because you did what they've charged you with?
Yes, Your Honor.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Harley is not competent?
No, Your Honor.
All right, Mr. Harley, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily.
Yes, Your Honor.
Find that you're mentally competent and you understand the nature and the consequences of your pleas. In cause number 24, DCCR 2148, find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of criminal mischief. Sentence you in accordance with your agreement to a term of 1 year in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 0739, also find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of harassment of a public servant. Sentence you in accordance with that agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I've handed you the trial court certification in each case that shows these were agreements and that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Kashawn Pugh.
Okie dokie, friends. I think we need to leave it here for today. I hope you all had fun. It was a little bit of a quieter day, but enjoyable nonetheless, I think. Got to see some good court. We'll be live on this channel again tonight, 8 p.m. Eastern, 5 p.m. Pacific for Sidebar, where we're going to at least start our discussion based upon the case we had in Judge Boyd's court yesterday, where there was the sentencing of the older gentleman with MS who believed he was soliciting a minor online. So we're going to start there and see where it goes. So I encourage you to join us for that. Again, that'll be 8 p.m. Eastern, 5 p.m. Pacific. Also, I did not shout out this channel's sponsor, Aura, today, but it is linked down in the description. And as always, I encourage you to give them a look. It's aura.com/TCF. You get a 14-day free trial if you use that link. And everybody who has signed up for it has reported back that the amount of personal information that Aura is finding and removing that's online is staggering. So give it a look. You certainly can't hurt yourself. It's 14 days to give it a try, and I encourage you to support those who support the channel. So do that, and then that encourages them to keep supporting the channel, which, you know, helps keep the lights on here. But again, we'll see you this evening. In the meantime, have a great day. Oh, there's 3 great videos going up today, too, at 2, 5, and 8 o'clock Eastern, 11, 2, and 5 o'clock Pacific. All 3 of them are real good today, so be sure to check those out, too. But again, go have a great day, and we'll see you all tonight. Take care. God bless.